Marwadi, my lord, family. Your lordship knows how daughters.
That's an anachronism.
No, my lord, that's not. It's truth. It's truth in our society because your lordship is dealing with a social problem. Here, this is a social problem.
No, you
and
said
your
a middle
lordship-
class Marwari person.
Yes, my lord. The daughters are not.
Yes. Appreciated, need not elaborate.
Yes. So what happens is, my lord, that the money which came from the mother while she was looking after me, I paid it back once I got money from him.
No, what about those transactions?
I'll tell you, lordship. I'll tell every details. I'll tell you, lordship. I've
Tell us.
taken every instruction.
Don't make it a first appeal.
No,
Tell
no,
it
no,
right
no,
now.
no. But I have to answer him.
Definitely, yes.
That's why, my lord, I have to.
Please
my
do,
lord,
please do. Please.
So I'm grateful to him that he actually, my lord, quantify the amount he had given me. This money which was sent to my mother was all from him. He paid those money to me, my lord, and I, my lord, in turn gave that money to him, to my mother, paid it back. 9 lakhs given to me by my brother. The brother has an HUF where, my lord, the brother and the mother, my lord, are the members of that HUF. I am not.
No, you gifted money to your mother. We don't
Not
understand
gifted,
the
I
link.
gave it back. I gave it back. She was looking after me all these years. I gave it back. Lord, your lordship will know that under the Income Tax Act, if there is a gift made, then there has to be a document above 5 lakh. It's not like a gift. It's like giving her back what she had spent on me.
So you have to give back whatever your mother spent on you to her.
To her. I did it. And it's not it might look
So
odd.
if you started repaying our mothers, I mean, is it
Mothers are never repayable.
no? But you are seriously saying that you have repaid your
I have repaid my mother personally
by taking it from your husband.
by taking it from my own income. I have done it.
Your own income
Yeah,
from some other source.
no, well, I was talking about myself. With respect to this, Willard, giving it back to the mother is not something, Willard, which can happen.
We generally don't give it back to our mother. Whatever debts we have to our mothers for our upbringing, we generally don't. That's not that against the normal course of transactions of life.
After marriage, things like that, Willard.
That's very vague, Mr. Chatterjee.
I say,
it
Willard,
seems to be an alibi.
It's not something. Willard, if I'd kept the money here, what would have
You
been the
gift
problem?
back the rupees. You take from your husband. You gift back 13 lakh to your mother to repay her debts which she has spent on
Your
you.
lordship need not even get into that. Suppose, Willard, that money is with me. That money is with me.
No. How do you explain those gifts? Those are reflected in your statements of account.
Suppose, Willard, I did not gift that money. It's with me. Where has it come from? That is where, my lord, your lordship has to investigate in my respectful submission. Where has it come from?
We are tired of investigations of unaccounted money.
My lord. So this is not unaccounted. This is from, my lord, a bank account. This is not unaccounted.
What is the source of that income?
Exactly. The source is that money that he's given me. Kindly takes up, my lord, my assets.
So therefore, he has a point in saying that you don't require the money. He pays to you an amount. You take it as alimony and gift it to your mother.
My lord, your lordship knows better than me, my lord, about this. It's not about the need. It's not need. It's about being commensurate with whatever, my lord, I was there when I was in America. It's commensurate with that. Need is never, my lord, the.
But if you pay your mother with the alimony amount, you don't need it.
I'll tell you, lordship.
Your mother may need it. We don't.
My mother might not need it, but it is something that what was the alimony amount paid for? Was paid for my upkeep.
Yes, absolutely. Yes.
So she has paid for my upkeep when he had not paid the money. That upkeep, pilot, is being now repaid to her. So that's not a crime. And that doesn't mean I don't need it.
You don't have to commit a crime to have your alimony application rejected.
Not at all. But I would have if your lordship comes to a finding that money has come to me from somewhere else, it's not about need.
You have to explain.
It's not about need. It's very different from that.
Alimony is not about need.
No. Alimony is to be there as.
But the section 36 as well as 24 start with that. If you don't have income sufficient to maintain yourself.
Exactly.
So if you spend that in gifting to your mother 13 lakh, that's not at all your need.
I'm not being clear to your lordship.
No, you are not. Our failure.
I am trying. No, Milord, it's my failure. Milord, I need certain money to keep myself the way that I was, Milord, in America. When the proceedings before the DV Act was going on, I did not get that much amount of money. So who paid me that money? Somebody else paid me that money. Somebody else spent it on me. So that point of time, at that point of time, my lord.
So it's a payback to your mother for what she spent.
What she spent for my
But what should have been spent by him?
What should have been spent by him?
Alright.
So that is what, my lord, that payment to my mother, my lord, reflects. It can be that. It can also be, my lord, that thy mother is invested somewhere. I don't know about that.
No, what your mother does, we are not bothered.
I'm not.
You have given, we are bothered with that one.
My lord. So my money, which I have spent.
Two tranches, 13 lakh and 7 lakh.
Yes, my lord. My money, the way I want to spend it is not for him to see. I will get money from him on law with commensurate to the status of the husband. And I spend that on shopper stop, or I spend that on a property, or I gift it to somebody, my lord, is not for him to see.
So you say it's not need based.
It is
but
not
commensurate. The yardstick is only commensurate
with the status. I should be the way that, my lord, my husband is capable of keeping me. I cannot be, my lord, anywhere lower than that. And that's what the Supreme Court has all along said. So.
You cite those judgments also on this point.
Definitely.
That it's not need-based. We'll just take the paragraphs.
My lord, Rajneesh is on that. And if your lordship wants, even our court has said that it should be the need should be commensurate with what?
No, commensurate with understand. In the first place, it has to be a need.
My lord, your lordship.
So you say need, this need aspect is rather mellowed by or circumscribed by that balancing factor.
That need is relative.
That commensurateness has to be ready to need.
Into need. And that need, my lord, is relative. My lord, what I would need is 1,000 rupees a month. What would my learned friend need, my lord, would be, my lord, 5,000 a month. So that need needs to be commensurate with the status of the family.
Very well, get your point.
My lord.
So need based, not exactly need based,
yes,
but commensurate with status.
With the status of
very well, yes.
So that commensuration is to be read into the need thing. My lord, somebody needs, my lord, an ambassador car, and somebody needs, my lord, a BMW.
Not elaborate into examples.
That is no. It's
there'll be no end to it. Yes,
that is what it is. So what he is trying to say is that I have not used it. It's not for him, the courts to see how I have used it. That's not what the Supreme Court has ever said that. My lord, he had made yesterday 4 or 5 big submissions and 2 or 3 small submissions. The first submission was, my lord, that wife is educated.
Capable she's a bachelor of architects.
Yes, she's a bachelor of architect, capable of earning, and is earning.
Yes.
And he is the owner and founder of ABN Design and Suppression. This was, my lord, his big submissions. That's what he nomenclature.
Yes.
Takes up Neha Rajneesh versus Neha once.
Yes. Yes.
Kindly takes up, below page 331 there. I'm shortening it, my lord, because your lordship wants me to.
Thank you.
Takes up 331. That's the, my lord, the crux of this submission.
Yes.
Financial status and reasonable needs of applicant, lordship got. It is no answer to claim of a maintenance that the wife is educated and could support herself. The court must take into consideration the status of the parties and the capacity of the spouse to pay for her or his support. No doubt it is relevant as to whether the applicant is educated and professionally qualified and is an independent source of income or not, but the court has to see whether the income is sufficient to enable her to maintain the same standard of living as she was accustomed to in her matrimonial home. I am on, this is the...
But here, Mr. Chatterjee, the court has quoted section 20, subsection 2 of the DVA.
So that may be... Same as...
Language is same.
Also remember section 24, Miller, was way
This proposition is there, has been there
way-
for some time. Yes.
there, Miller. There's no change in this at all.
No, since you're citing, because it
That-
cites a particular section, that's
Same
very good.
thing, Miller. There is no change in this law ever.
Very good.
So I have to show Milord that I am earning this amount of money. He would have to show that this amount of money, my lord will come to a finding as to what is the Milord, the amount which is to be given, deducted from whatever I am earning. Now, whatever I am earning, he's been very Milord vehement on my earnings. But has Milord, in my respectful submission, if I was drawing a salary from anywhere, a salary comes in monthly. Salary doesn't come in, Milord, at intervals of 6 months, 7 months, a year. Kindly have a look at the statement.
Yes, that is one of the factors we saw.
Yes.
It's sporadic.
Not even
3 or 5.
sporadic, Milord. The salary part which he has said is just 2 months out of the entire period.
And the amount is not much also.
12,000 rupees.
12,000 was the maximum.
12,000
5,
was the
7,
maximum.
12. Yes.
Maximum.
We saw those amounts.
Yes. Milord, was the biggest amount was 9 lakhs.
It was? Sorry.
9 lakhs.
9.
Which was gifted to me, Milord, by my brother. Why it was gifted to me by my brother, Milord, if your lordship takes it up once, I think from the accounts itself, it will be quite evident. Go straight up, Milord, to the, when the accounts start, is at page 29.
Of?
Of, Milord, the affidavit of asset.
Your affidavit of assets.
My affidavit.
Yes. Page 20.
Opening balance.
9.
This is, Milord, in 2022.
Right.
17,290. That's my opening balance. Then, Milord, your lordship comes down, sees my expenditures. Krishna Bhumi holiday, 5,000 something. Then goes down, Milord, to 26th of August, 2022. And everywhere the expenditure your lordship will find is at Dosa Coffee, is at Shoppers
This is your personal life, Mr. We don't want to include there.
He says these are, Milord.
No.
The affidavit, he
Definitely.
has said that these are payments made to, Milord, the
corporates and all. No, we did not accept that at that point of time.
That's Milord, in my respect.
We don't want to include into your personal life. You have your life. Yes.
So this came from Abhishek Fogla at 9 lakh. Why? Because the sister was in such a destitute form that she did not have anything, Milord, to do about it. That's when the money came in. Then, Milord, he started paying, Milord, if your lordship sees, rather, I should explain this at page 30, 19 September, Milord, 12,432. And which has been explained, Milord, in my affidavit, which your lordship will find at page 11. There were 2 transactions of 12,400.
Your affidavit in reply?
In my reply. 12,432, Milord, which came from Ashoka Hall. I went there, Milord, as a guest lecture for 2 months. And I've given that as a reply, as
that is that page in your affidavit of asset. No, affidavit of asset, which page?
In the affidavit and reply. It's the other.
No, in your affidavit of asset, it's shown.
It shows, Milord, at page 30.
What is the amount?
12,432.
Oh, that.
And the next.
It says salary for September.
Yes, sir. And then October, Milord, there is no salary. And then it comes, Milord, on 29th of November 2022.
What about the 31st of October 2022 salary? What is that?
I'm sorry.
Oh, you are starting from 9th of September.
Then it comes to, Milord, there is one at Lance, 18,640.
What is Lance?
That is the Ashoka Hall mode of payment.
And this you have stated in para 11 of your reply.
Of my affidavit reply. And then, Milord, the money starts coming in from him. Your lordship will find 30 top 4/1/2023. Lordship will find 70,000 comes in from him. And that 70,000 goes on forever. And all these, my lord, your lordship will
By
find.
79, 60 plus 10 arrears.
Yes. And your lordship will find the expenditure that your lordship will find is either on food or my personal life, whichever it is. So I have used that money that he sent. Lord, I might not have used it in a lavish way, but I have used that money. Because he was trying, Lord, why I'm showing your lordship is that his submission that I have not used that money. No, I have used, I know what my limitations are. I know what 70,000 rupees in a month is. In today's world, my lord, to survive on 70,000 rupees a month is not very easy. Not very easy. It's just because I haven't used it in a lavish manner doesn't mean, my lord, I haven't used it. All this is about food bills. Food bills, a little bit of shopping here and there. I'm a woman after all. It's my personal thing. I am entitled to do it.
Men don't need to buy anything.
And my lord,
because the women buy for them.
Women buy for them.
So don't make those gender-based comments. Wrong quote for that.
I can say, my lord,
because I know for myself, because I don't have to go to the shop because my wife buys it from.
Well,
So
that's in a congenial atmosphere, but when you're alone, my lord, it's different.
yes.
Now he's been very, my lord, vocal about trial court proceeding. I don't think your lordship is serious on that at all. If I have not filed it in the trial court, I can't file it in the appeal court. Below, that's not something which the law is. The law says at any stage of the proceedings, whenever I want to, I can file. Below, it's my bona fide that because the DV Act money came in, I did not, my lord, trouble him at that point of time. Very weirdly, my lord, your lordship will find, I came back from America, my lord, sometimes in 2022. The suit was filed on 21st of December 2022. My lord, it was degreed or rather dismissed on 12th of August 2024. And by that time, on 27th of March 2023, my lord, the order from the DV Act came in.
So almost throughout the suit, it was there.
My lord, it was there. So it's my bona fide, my lord, that I didn't trouble him. But he's taking advantage of my, my lord, being, my lord, probably nicer to him. Now, what would have happened is, if I had filed this Section 24 application in the trial court at that point of time, entire proceeding would have been stretched. But now I am seeing, my lord, that he's taking advantage of that, and I need to be commensurate with him. He's earning about 14 lakhs a month. So he can't get away with murder in the colloquial sense. My lord, the suit was dismissed in 2 years' time. Why? It's not usual because, my lord, he was living in America. He had made an application in this honorable before this, my lord, the court, that since I live in America, my cross-examination may be completed when I'm here. So his cross-examination was finished, my lord, in 3 days, and the matter went, my lord, to the hearing board. And this way, my lord, the suit was dismissed. So it's not that because, my lord, I've been lying over my rights or something. My rights were there. I didn't know. He didn't disclose his income, my lord, in the DV Act. Before the DV Act, my lord, he had not filed his affidavit of assets at all. Here also, my lord, with a lot of difficulty, my lord, the affidavit of assets have come in. So the law as it stands today is that the wife should be commensurate with the status of the husband. It can't be that you will ride a BMW and I will, again, your lordship doesn't want it, I don't want to, that you will ride an X car and I will ride an A car. If you ride an X car, I will also ride an X car. It should not be oppressive. Of course not. Somebody who earns about 1 lakh a month, the court can't come up and say, please pay the husband 99,000. No, that's oppressive. But if the court comes up and says that give her 10,000, that's not oppressive. That's reasonable. The court wants the Supreme Court wants the courts to be reasonable in their approach. Now, today, my lord, he talks about that 40,000 rent on my needs, though I don't think that is relevant, but I'll explain that to your lordship. My lord, what happened is, it was only in February that, my lord, that I did not want to stay, my lord, with my father. So I, my lord, got into an agreement only in February. I have the agreement also with me. It's only in February because that's why.
Which year?
This year. This year. And I have the agreement with me as well. 40,000 is reflected there. So because it was not there when I was filing it, my lord, that is why it could not have been included here. So
you're still there. You're still there.
I'm still with my.
You have to having to spend that money still.
I am now spending that money, my lord, because I have now shifted to Active Acres in the other building. He was also talking about, my lord, that change
the rent, 40K rent
is where I'm staying now.
And February 25?
Is that agreement?
Yes, that is what we are asking. You are still staying there and spending that money.
Yes, sir. I'm sorry, it's January 25. It's my mistake. So my respectful submission is, it's not always that the courts would see, my lord, that whether there is where I'm living a luxurious life out of my husband.
He was more on probably not on luxury for this, but how can you spend 40,000 from your 60,000 income?
That was the
maybe
no,
that.
I did not.
That was one of the aspects.
That's what he was incorrect on. I did not.
Yeah, so you got it only in January.
In this year. So I wasn't spending that. I was staying with my father. Now I'm moving up because my brother, their children, they're all growing up in that.
Very well. So you are now in Active.
I have a right to stay separate, and especially when my husband can. Lord, if my husband was earning about 1,000 rupees a month, I could not have. I would have to be commensurate with that 1,000. But if my husband earns 15 lakhs a month, then I should not be commensurate, my lord, with 1,000 or 5,000 rupees a month. This is what I'm trying to, my lord, submit before your lordship, that if your lordship has found that this 15 lakhs and odd or something, my lord, which he earns is admitted, then my alimony should be in tune with that. Now, my lord, if I may say, my lord, a doubt was expressed by your lordship on that founder part.
Yes.
My lord, if your lordship turns to that document once. My lord takes up their opposition. Right? One.
133 probably.
Yes.
Yes.
Lord, very interestingly, if your lordship looks to the top and kindly sees the date.
Yes.
These are all of 2020.
Yes, you said that in your arguments.
And this is a printout that they've taken in 23. That your lordship will find at the top left.
Maybe.
That's because they thought that I will file before the DV Act. Because that was the time, my lord, that the DV Act proceedings were on. So they don't have any contemporaneous document for your lordship to see, my lord, that I am earning something today. My lord, your lordship would obviously, my lord, find out from my bank statement what is, if there is an incoming thing from somewhere else. My learned friend has not pointed out at all. He is not saying, my lord, that I'm taking, my lord, money in cash and things like that. No. He has not even proved before your lordship, my lord, that this company belongs to me by any sort of document. If it's a company, my lord, it has to be registered somewhere. If it's going on in a business, my lord, there would be a trade license, which is easily accessible through the KMC, my lord. Records.
You could also rebut the presumption of correctness of this. You
I
could have obtained, because you worked there, you could have obtained the trade license.
At one point of time,
ABN designs is there, obviously.
At one point of time, I did. If your lordship wants, I can ask my client to give it to your lordship. I'm not afraid of it. Even the trade license also, my lord, it's 5 minutes in the KMC website.
Very well.
I can also give it to your lordship. My lord, after your lordship comes back, by that time I will search and I'll show your lordship.
What else, Mr. Chatterjee?
Your lordship,
we will come back for different matters as you complete.
That 5 minutes, my lord, I'll use to get that trade license.
What else remains? I mean,
there's nothing much remaining anymore on this at all.
Don't ask him. He'll be coming. We came across Justice Basu. So we had a talk about.
I'm sure your lordship
Yes,
spoke
yes.
about it.
No, no. He put up. I mean, he raised the issue.
I went
So
back.
we said that we were talking about that only.
Sir, I went back the other day when another second appeal was being heard by his lordship. I said, if you open your mouth about it.
But he stood by his comment.
He always, not every day he passes me, and every
Yes,
day
yes, he gave the background.
passes me. Every time he will Lord, bend over and see what is the
He does. He actually does that. He's very curious.
every day he
Yes,
does
yes.
so that he can take my case Lord, in court.
No, completely. I agree with you completely on that.
Takes my case in court. And then people start believing him. He's a judge. Everybody will believe him.
Yes.
And he's got somebody, my lord, on social media or my lord, on YouTube
Yes.
who actually, my lord, sits in his court and finds out these comments and puts them as a reel.
No, he has probably turned off the
No, he hasn't.
live stream. He
I
told
was
us just now.
matter on Milord Onnoprashan at Dhol, whether the right is creative. That became a reel. অন্নপ্রাশনের ঢোলের মামলা জজ উকিল অন্নপ্রাশনের ঢোলের মামলা নিয়ে মামলা করছে and became a below a viral reel all over.
We have made so many comments in court even today. Anyway.
It's not a problem in my lord's court. Two courts, Justice Amrita Sinha and Justice Basu. These two courts
No,
are
no, taken out of context.
Absolutely.
And we become internationally popular for the wrong reasons.
Absolutely. And there's no dispute on that.
Yes.
Time takes up.
Yes.
Rajneesh versus Neha once. I'll conclude.
Yes.
Milord, your lordship would remember, Milord, Rajneesh versus Neha was a situation where the Supreme Court took up, Milord, every aspect of maintenance, every act, Hindu Marriage Act, Special Marriage, every act. Finally, turns to Milord, page 371, where Milord, they have said criteria for determining quantum of maintenance. So these Chennai judgments would not at all, Milord, come into play in any manner whatsoever. Looks to paragraph 77. The objective of granting interim or permanent alimony is to ensure that the dependent spouse is not reduced to destitution or vagrancy on account of the failure of the marriage and not as a punishment to the other spouse.
This was what your learned friend was reading.
There is no straitjacket formula for fixing the quantum of maintenance to be awarded. The factors which would weigh with the court inter alia are the status of the parties, my lord, reasonable needs of the wife, my lord, and dependent children, whether the applicant is educated and professionally qualified, whether the applicant has any independent source of income, whether the income is sufficient to enable her to maintain the same standard of living as she was accustomed to in her matrimonial home, whether the applicant was employed prior to her marriage, whether she was working during the subsistence of the marriage, whether the wife was required to sacrifice her employment opportunities for nurturing the family, child rearing, and looking after adult members of the family, reasonable costs of litigation for a non-working wife.
So educated and professionally qualified is also there.
Yes,
contrary to what you were saying, that capacity is not.
I am earning out of that. I'll come here.
It is followed by a semicolon and disjuncted from the independent source.
Once your lordship reads on, your lordship will find that. Then, my lord, I'm not troubling your lordship with what is there in the judgment. Turns to 80.
Right.
On the other hand, my lord, yes. On the other hand, the financial capacity of the husband is actual income, reasonable expenses for his own maintenance and dependent family members whom he is obliged to maintain under the law, liabilities, if any, would be required to be taken into consideration to arrive at the appropriate quantum of maintenance to be paid. The court must have due regard to the standard of living of the husband, as well as the spiraling inflation rates and high costs of living. The plea of the husband that he does not possess any source of income, this is, of course, it's not in our case, ipso facto does not absolve him of his moral duty to maintain his wife if he is able-bodied and has educational qualification. A careful and just balance, this is what I was on, Milo, there must be drawn between all relevant factors. The test for determination of maintenance in matrimonial disputes depends on the financial status of the respondent and the standard of living that the applicant was accustomed to in her matrimonial home. The maintenance amount awarded must be reasonable and realistic and avoid either of the two extremes. That is, maintenance awarded to the wife should neither be so extravagant which becomes oppressive and unbearable for the respondent, nor should it be so meager that it.
So both of you are relying on this, obviously, because there are components for both of you.
What I am saying so.
Yes.
What I am saying so. Kindly keep a balance.
Hmm.
Your Lordship would find that if I have earned something, deduct it. Kindly deducts it. If there is evidence on record which would show, my lord, that I am earning an amount of money from where I am working, deducts it. So the first and foremost, my lord, we go back to that single bench decision of our court of Justice Justice Tapun Datta's, where his lordship held initially that the court has to first come to a finding about the income of the husband today. And then there are, my lord, safeguards given that if the income reduces, he can come to court and ask for, my lord, reduction. It's not, my lord, that it will be hit by res judica. Change of circumstances, you come and tell the court. And if his income goes in, I come up before your lordship and say that, look here, his income has.
Yes, that is always there.
And if he finds evidence, my lord, that I am now in earning money, he will come and ask for, my lord, variation.
That can be.
So that is always there. So my respectful submission, my lord, from the entire thing is, finds out his income. If your lordship finds that I have income, kindly deducts it from there. I have no problems whatsoever. Suppression, there is nothing. He said, I must have suppressed. Kindly appreciates that. There needs to be actual suppression, evidence before your lordship saying that, look here, this is what I have suppressed. My lord, if it's a company, I have evidence how, my lord, a company works. He will get an just, my lord, by a click of a few buttons, he will know. If it's a sole proprietorship, it will have a.
Did you get that in these 5 minutes?
I did. I did.
It shows that it belongs to somebody
else. If your lordship wants to see, I can.
No, we won't. After hearing,
it belongs to somebody else. That's why they haven't shown. I say, my lord, take an adverse inference there.
We'll proceed on the basis of what is already
on record. So if there was any evidence to that suppression, I bow down. A Facebook post made in 2020 where I've just come in 2019 from America and trying to make out something to the public that, look here, I can do something, doesn't ipso facto mean, my lord, that I earn money. My lord, what your lordship needs to see.
You came back from America in 2020?
19.
2019.
The tickets are also an next, my lord. Now, what happens here is the Supreme Court here in this judgment says the liability of a husband to take care of the wife is at a higher pedestal. It says so.
No, under Special Marriage Act it is, because in a sense.
Yes.
Because the husband does not have a right to claim alimony and the other.
But here, on a general principle, my lord, in the earlier paragraphs, your lordship will find the Supreme Court says it's the High Court.
And this is something peculiar, Mr. Chatterjee. I mean, the Hindu Marriage Act has a flavor of religion in the sense that the word Hindu is there. But it's the most, this is not a comment on any religion. I mean,
it's a balance.
It's the most balanced because here the husband can even claim alimony.
I made this.
It's progressive, very progressive.
I made the submission long time back.
And the divorce grounds were there when Christian marriage did not contain those. And still doesn't contain some.
Absolutely.
So in 1955-56, that era, those 4 laws came.
Passionate submission in this court before Justice Shonji Banerjee.
Yes, it's rather, I mean, odd. I mean,
it's very
so very liberal.
Nobody has looked into it. Beloved, what happens is I made this submission on behalf of a husband that now with 4, 5 places where even 125, beloved, what has happened is there was a cap there. When this adjustment thing came in,
yes,
there was a cap in 125 that you could only pay for this amount of money and not more. So if a wife chooses to go under 125 and gets an amount there, you should not, the husband should not be.
But you're right.
But it's been negated even by this judgment.
No,
even
not
here it says adjustment. Why adjustment? Because if there was a capping, I would have understood. I'm here just on not on the matter. But if you have gone somewhere where you have the entire thing on, why would you again come back and put litigation on somebody else again? But that has also been negated by this judgment. No, you can go everywhere.
Well, I was in the profession. I had I mean, most of the appearances for the wife was monopolized by Justice Basu.
Basu.
Therefore, we had mostly the husband's cases.
He would be. I think he gave
some which in which Mr. Basu was not there for either side. Then we might have had cases
I have
to
also
represent the wife also.
in that
Mr. Basu was monopolizing in alimony. 99% of the alimony matters, divorce alimony, and 99% of the wife's cases. So we had the husband, the few cases
give a discount to
which he left for us.
discount to the wife.
we'll speak about that. We are
Somewhere else.
we are continuing.
On.
So let us not. These lighter vein things become the main crux of.
This was what our Milord. We are always in Milord running. We are always
Transparency does not mean you have to be seen through entirely. I mean, you have to have something on also.
The problem is, Milord, that there is people forget balance.
No, I personally feel, Mr. Chatterjee, because we are at a nascent stage of this transition. I mean, becoming online and YouTube thing. India is learning these things. After a while, I mean, after a few years, we'll get accustomed to the common people will get accustomed, and you lose interest in all these things. Next generation doesn't have any interest in all this.
Who's gone on to a courtroom from a toilet?
Yes, lavatory to be precise. That was the language used.
A lavatory to be.
That was the language.
That was the language.
2 lakh cost.
Who does that?
Word fellow. 2 lakh cost it was. Anyway.
1 lakh rupees cost.
1 lakh.
Should have been thrown out of the profession.
Why? No. For going to the lavatory.
to start talking.
Don't be so harsh.
No, the court needs some sort of.
Mr. Motha, you want to add something because Rajneesh versus Neha has something for both of you. So you need not respond to that.
On that. 2017-15 SSC
We gave you a mandate not to ask him.
Yeah, this was. He has a.
What is this?
It's on Milord the status and.
No, give the citations to you.
2000 what? 17-15 SSC 901. 801.
2015 7
17-15 SSC 801.
Stop. This is on what proposition?
That front portion, Milord, your lordship will find. Chashma took care. Maintenance dependent on factual situation and while determining the same to make maintenance independent.
In a particular paragraph?
Lord, it's 12 to 17. But Rajneesh takes care of everything.
Wide discretion in the matter of cannot be arbitrary or capricious. Definitely, it cannot be.
Rajneesh versus Niyamila takes care of the balance. I am on balance completely.
So, Mota, you want to say something? Yes.
My lord, just 2 small points, my lords. First of all, what my senior has stated, my lords, that has not been very specifically pleaded in the affidavit in reply. So something which has not been very specifically pleaded in the affidavit in reply, my lord, it cannot be brought down as an argument, my lord. Now, second thing, my lord, which my senior has raised, my lord, is that ABN design, whether I can prove, my lord, that she's working from gain for ABN design, my lord, which has been specifically pleaded, my lord. And my lord, if kindly sees just the account statement that there are transactions from ABN Design, my lord, that she is receiving sums of money from ABN Design and that she is working for gain. He raised up a point, my lord, that on the basis of just a social media document way back in 2020, which he had came, my lord, and it was printed in 2023 and that we are using in 2025 is my lord, very at the very best, my lord, very, very speculative, my lord, because the bank account statement says for it,
arguments on this.
Both of us in all our fairness have submitted, my lords, and rest we leave up to.
So we cannot decide it right now. So we'll have to go through because of all the judgments. Thanks to you and
both of us.
We'll have to at least deal with the judgment, or make a show of dealing with the judgment. No, we'll deal with the judgment. Definitely.
The thing is on.
No, we'll definitely deal with the judgment. That's why we end with that writer. This is somebody who cannot understand this much humor deserves to be in that cycle.
I agree.
We both agree to that, my lord.
They deserves to be in that cycle of casting blames and all. Can 1 of 2024 Heard Learned Counsel hearing on Can 1 of 2024 is concluded. Judgment is reserved on the said application. As soon as possible, pass the order and put it as for orders and pass the judgment and then continue with the next. Is there any other pending application in connection with the appeal?
No pending application.
So we'll decide this and then pass the usual directions for preparation of it.
Yes, my lords. Obliged.
Notes could make extension. দেখো শোনো না আমি দুটোই ঠিক করে বলতাম একটা যদি আপনার দরকার ইয়েস
Husband will not respond.
again
Uh,
So,
Mrs.
Section 5 application, will your lordship directed the opposition and reply to be filed, but it's my opposition.
Yes.
Mrs. Riya Banerjee appearing in the
use the microphone ma'am
Mrs. Riya Banerjee appearing in this matter. She is cold and fever. My lord, please, not today.
you should have been prepared with a reply at least
The reply is being used, Lord, we have been served with.
why isn't don't you have a copy of the brief file a reply at least when should you keep it when will she become well we don't know you should have a basic preparation ma'am you are her chamber junior this is an alibi this is what section 5 section 5 you should have some basic preparation in the matter tell her we have said this we have expressed our displeasure at you not being even having a copy of the brief and not being prepared on the basics if you want we can record that in our order but that will prejudice you affidavit in opposition filed by the opposite party respondent opposite party today be kept on record full stop on the prayer of the appellant comma the time for filing reply is extended for a week from date full stop the matter be listed next on April 2 2025 under the same heading. You should have a copy of the brief tell her that you have told that the junior should have a copy of the brief and should start the matter and in reply cases file the reply at least then ask for time we will grant you time yes
Item number 13, I am saying for fixed at 2 p.m. my lord, and the
why
learned advocate engaged in code number 35.
you are there you should start the matter you have served copy on the other side
Yes, yes. Everywhere
you have to file an affidavit of service afresh
everywhere service.
so good service has been affected there is only one respondent right
Yes, yes.
what is the matter about
Matter about my application for
please take the microphone a bit closer to you the microphone should be a bit closer to you
my lord, the
yes
condonation of delay under section 5 and the matter
Achha, what is the period of delay approximately
22,200.
2200
Yes, my lord, days or delay only, my lord.
what don't use the expression only unnecessary what is the reason for the delay
Reason not, basically, my lord, client appeared in this case as in person, my lord.
this also seems to be drafted by him why do you take these briefs
I am not drafting this matter, my lord. My client drafting the matter, my lord.
oh there are serious allegations against the erstwhile advocate
Yes, yes, yes.
no you have to serve a copy on that advocate that is a standing practice
Much.
you have named the advocate in paragraph 5 and 6
Yes.
you serve a copy of this application on that advocate also
Mr. S.N. Guha, advocate for the plaintiff.
don't have to name him we despite service none appears for the respondent full stop affidavit of service filed to be kept on record full stop as such comma further service on the respondent stroke opposite party is dispensed with full stop however comma from the averments made in the present application for condonation of delay comma in particular between paragraphs 4 and 6 thereof comma serious allegations of a grave nature have been leveled against the erstwhile alleged against the alleged erstwhile learned advocate having instruction to appear for the appellant. Full stop. Next para. we are of the opinion that in view of such serious allegations, comma, the said learned advocate, comma, in all fairness, comma, should have notice of the said allegations and have his say on the matter. So accordingly, the petitioner shall serve a copy of this application on the said learned advocate mentioned in the above mentioned paragraphs, indicating that the present application shall next be listed on April 16, 2025, when an affidavit of service to that effect shall be filed by the by the learned advocate for the petitioner to that effect. Please come back with a notice to that person. যাচ্ছে তাই বলে। যাচ্ছে তাই স্ট্রাইক অফ ডিসমিস করে দেবো অ্যাপ্লিকেশন দেখি অ্যাডভোকেট এসে বসে ফর্মালি রেকর্ড করে একদম ডিসমিস করে চ্যাংড়া নিউজ
Lord,
Yes, Mr. Parmar. Two appeals, right?
yes, Lord, suit for declaration of tenancy right
Dismissed,
Decreed,
counterclaim
decreed.
decreed, yes.
and counterclaim for eviction of trespasser, Lord, that has been dismissed. Lord,
Dismissed.
that has been dismissed. Suit for declaration of tenancy
You are-
right decreed.
Acha.
I'm the landlord.
Oh, acha. Right. The other way around. Yes.
Trespasser, section 2G.
2G. Acha. So 2G has been dismissed because you have been held to be a tenant.
Lord, this is the reply.
So what is the application for?
Lord, the application is for injunction. Your lordship was pleased to grant injunction. Lord, let that be continued, Lord. In the
What
meantime,
was the injunction granted, Mr.
injunction, they will not create third party interest, Lord,
That let it be disposed of.
because they are not being getting Lord, prejudiced
No,
by
no, no.
this or any.
Disposed of the interlocutory application.
And Lord, let the appeal be
But the
made.
application was styled as an application for stay.
Lord, that was not.
We recorded
One was
something
for
on.
stay, the other was for injunction.
Oh, there was another application.
Injunction, we have,
The application we have dismissed must have.
Lord, that is pending.
it has not been dismissed.
Stay will dispose of because if that remains pending, then.
Yes.
So the injunction is can one.
Certified copy.
Can
that was
one.
pending. Lord, we have filed that. We had filed that in Lord FAT number Lord 5.
What?
FAT number
Certified
5,
copy.
Certified copy. Because
Did you dispense with filing of certified copy in the other?
Lord, your lordship did not formally because on the last occasion, Lord, the certified copy was not available with us. That's why your lordship granted us some time. Lord, in the meantime, we have filed it because one of the appeals, Lord, it was available. So we have filed it formally in one of the appeal. The other appeal, your lordship would kindly dispense.
But decree you have to file. But the same decree is, yes, counterclaim, right?
So
Very
that's why I brought that
Very
judgment.
well.
Your lordship did not want to get into.
The two present appeals arise out of the same suit, comma, one filed against the dismissal of one filed against the decree passed, comma, thereby declaring the plaintiff stroke respondents as the tenants in respect of the suit property, and the other the dismissal of a counterclaim filed by the plaintiff stroke appellant seeking eviction of the respondents as trespasser within bracket under section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997 square bracket বাইরেটা square bracket করে দিই full stop next para learned counsel appearing for the petitioner submits that in the event third party interests are created during pendency of the appeal, comma, unnecessary multiplicity will arise and the rights of the appellant would be prejudiced, full stop. Upon hearing learned counsel for the parties, comma, we find a sufficient prima facie case having been made out for hearing of the appeal on merits, full stop. Accordingly, can 1 of 2025 is allowed on contest, comma, thereby restraining the how many respondents?
No, there is only one.
Only one.
Very well. Thereby restraining the respondent and or his men and agents from creating any third party interest in the suit property and or dealing with and or encumbering the suit property in any manner till disposal of the appeal. Push up next para.
At the same time, my lord, they will not disturb my position also because they are
But
admitting.
you have not filed any application.
I have not
They
filed.
cannot disturb your power. How can they disturb?
Kindly.
No. There is no prayer to that effect. Why should it? Next para. Insofar as
He is in
there are two can. Oh, acha, in the other.
FAT 4.
আচ্ছা যেখানে বললাম না can 1 of 2025 filed in connection with FAT 5 of 2025 is tapaja bolo. Next para. In view of the above order, comma, we find that there is no scope of grant of any stay in respect of Can 1 of 2025 filed in respect of FAT 4 of 2025. Full stop. Accordingly, we dispose of the said application in the light of the order passed in connection with the injunction application without an order as to costs. Full stop. The learned counsel for the appellant submits that the appellant has filed, comma, in the meantime, comma, certified copy, one set of certified copies of the judgment and degree passed by the learned trial judge. Full stop. Since both the appeals arise from the same suit, comma, we dispense with filing of further copies of certified copies of the judgment and degree of the self-same in the self-same suit in connection with the other appeal. Full stop. Next para. The in view of the appearance of the respondents through their learned advocate, comma, you are appealing for all.
Only one. Because
Acha,
Milord, 2 to 6, I'll Milord seek for dispensation.
why
Pro forma, Milord, they are on my side. They are landlords.
2 to 6 acha very
2 to 6. They are on my side. I'll
in
give
view
them.
of appearance of the respondent number 1 through their learned advocate, comma, service of notice of the appeal is dispensed with on the said respondent. Full stop. As far as respondent numbers 2 to 6 are concerned, comma, since they have been arrayed as pro forma respondents and no relief has been sought substantially against them, comma, service of notice of appeal on the said respondents is dispensed with. Full stop. Next para. The appellant shall prepare and file. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellants shall prepare and file the requisite number of composite paper books in respect of both the appeals within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeals for hearing as and when the same as and when those are ready for such hearing.
Finally, record Milord that we have filed the affidavit in opposition.
আচ্ছা প্রথম সেন্টেন্সে অ্যাড করে দাও affidavit in opposition filed by learned counsel. You have filed reply.
Reply is also.
Affidavits in opposition and reply filed to be kept on record. দুজনে affidavit of service reply না একটা হয়তো অন্য জজের কপিটা ঢুকে দেন অরিজিনাল যখন yes. Who is appearing?
Chakraborty is appearing, Mr. Chakraborty.
Mr. or Mrs. You should have informed Mr. Kaur he's waiting from the morning. This is not proper. Should have informed him.
It's my fault.
Mrs. Chakraborty is appearing. He's my brother-in-law, so therefore I have to release the matter, Mr. Kaur. I'm extremely sorry. I mean, you should have been informed in the morning.
Caveat.
Don't do this ever.
No, Milord,
He's waiting from the morning. I'm seeing him.
Milord, it's my fault.
Lord, one prayer I will remain.
Yes, Mr. Kaur.
I find it is marked defective.
Certified copy of the impugned decree has not been filed. Therefore,
Decree has not been drawn up as yet.
so
Judgment has been filed, certified copy of the.
judgment has been filed, but because the rules prescribe that that has to be filed and the valuation and the other details cannot be tallied with the memorandum unless the decree is filed. That's why, Mr. Kaur, that
The decree has
no
not,
limitation will not run
limitation will not run.
because now the order 41 is clear, yes,
It's from the judgment.
but it remains defective. The appeal cannot be heard.
Parties means name of the.
No, no, no. You have to file the decree, certified copy. How soon can you file it? You don't know when the decree will be drawn up. How can you?
That is my.
So better not to pass anything on that. I will leave it for the appropriate bench where it is assigned. If you can get it drawn up in the meantime,
One more direction, my lord.
yes.
I find that a supplementary affidavit has to be filed in the application.
We'll grant you that liberty and serve a copy on that.
Very well.
Good.
Very well.
Learned senior counsel appearing for the appellant seeks leave to file a supplementary affidavit to bring on record certain further facts. Full stop. Such leave is granted. Full stop. An advance copy of the same shall be served on the learned advocate for the respondent. Full stop. Next para. At this juncture, it is pointed out that one of the relatives of one of us within bracket Amar Nam is appearing, had lodged a caveat and has already entered appearance on behalf of the respondent. Full stop. Accordingly, for the ends of justice, the matter is released from our list with liberty to the parties to seek an assignment from.
Caveat has been filed by somebody.
What is the name?
Zubair Ahmed.
Zubair Ahmed is junior of it.
Oh.
Very well. Is appearing for the caveator, for the ends of justice, let the matter stand released from our list with liberty to the parties to seek an assignment before the appropriate court. Zubair Ahmed is a junior of Mr. Shukanto Chakraborty, who is my relative.
From the next time, I will inform.
You have to inform the other side. You know who is appearing for the. They are sitting from the morning. We are seeing.
No.
Yes.
I am praying for short person.
No. Start the matter. Where is your brief? You are the chamber judge. Who is appearing? Devashish Kundu. Sure. You are his chamber junior.
I am familiar.
Why is he not prepared with a brief, Mr. Shur? He has to start the matter. Give him the brief. He has to start. Please stop this practice of not giving a copy of the brief to whoever is asking for time. You are sufficiently senior now. He has to start the matter. Give him the brief. What is the application for? Read out from the prayer. How long has he joined practice? Mr. Shur, how long has he joined practice?
Well, he has joined more than 10 years.
Very well. He is new with you, but he has to start somewhere. What is the prayer portion? Read out the prayer portion. Yes, Mr. Shur, what is the matter?
This is the suit relating to the partition.
And please ask your typist not to spell latches as with a T. For the first time.
First time. Well,
Serve copies of both the applications and come back. The appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025 on the respondent only 1 to 7.
1 to 7.
Respondent numbers 1 to 7, indicating that the applications shall be listed for hearing on April 16, 2025, when an affidavit of service to that effect shall be filed. Push up. What is the suit for? What was
for partition? Suit for partition. There are excess share of the suit.
But then all the parties have to be served.
These parties and the lower court, these parties are private parties are not pro forma respondent has not been parties. Only two pro forma respondent
were not parties or did not contest.
Did not make party.
Oh, you are the defendant in that.
I am defendant number 6.
Then you have to serve them copies all the more.
Defendant number 6. I am.
No, jeta bolam to serve copies on respondent 1 to 7 na kore on the respondents.
That is 23 up to 23.
Up to 27.
27.
তারপর যা বললাম তাই returnable when the বললাম affidavit search. Come back on that. Third of all, they have to have a say in the matter.
They have to say, in the court below, they have been only implemented.
That must be one of your points, non-joinder. So they have to be implemented here.
Yeah.
If they come and say that we are not necessary parties, you are gone. On that ground. Yes.
I beg to appear on behalf of the respondent.
Appellant. Yes. What is the matter about?
Earlier occasion, my lord, your lordship directed me to file an affidavit about the surname. There is a difficulty. So 10th of March 2025.
Affidavit regarding what? Please remind.
My lord. Surname, my lord. In a caveat, the Pamanik, PRAMANICK.
Surname. You have filed that?
Yes. I have given the advance.
Oh, we gave you an option either to file a Vakalatam or give a copy to him also.
Also, I have given.
Please wait for a minute. Just we'll check up what was the defect pointed out. This was the only defect?
Yes, my lord.
The others have been removed by you. Yes. The deficit code we put in telephone device. An affidavit filed on behalf of the respondent, indicating that the person signing the Vakalatnama as Shopon Pramanik, comma, the respondent, comma, is identical with the person in whose name has been recorded in the trial court's decree as well as the present pleadings. Push up, the same be kept on record. Push up. First application is for condonation of delay. Condonation was allowed. You are for the appellant. Move your application.
Allowed.
Already allowed.
Condonation was allowed, not application for injunction.
No, condonation was allowed.
Was allowed after appeal.
Achha, what is the appeal arising out of? Appeal is against what? If you came here to see me, see me through the YouTube. Why do you come to court? We are all available on live streaming.
Mr. Ashish Bhattacharya.
So what? Why are you before us?
Suffering from viral fever. So, প্রথমে time টা চান।
Move the matter. You don't have a copy of the application. You belong to his chamber. What is the application for?
Well, this is application for injunction. My lord, suit is for partition, declaration, and permanent injunction. My lord, the main point raised by my learned friend, my lord, is
No, suit is for partition.
declaration, and
This is against preliminary or final degree?
this is against preliminary degree. My lord.
So we'll pass the usual order. What is it? Fun in
The lordship
keeping.
has passed the order.
We'll maintain that till disposal of the appeal.
My lord, your lordship has passed the order on 10th of March during pendency of the application. The learned charges shall continue with the final.
Yes, yes, the usual. That is the
but
usual.
shall not drop the final.
No final degree. So we'll continue that till disposal of the appeal. Direct them to prepare paper books and all. An adjournment is, please, you tell him, tell the learned advocate for the appellant over phone what order we have passed. We are not very confident that he'll get the message. An adjournment is sought on behalf of the appellant stroke petitioners. Full stop, next para. However, comma, since the scope of the application is innocuous and the respondent is represented, comma, we refuse such adjournment and take up the application. Full stop. Since the present appeal arises out of a preliminary decree of partition and we have already granted an ad interim order to the effect that the final degree proceedings will continue, but no final degree shall be drawn up, comma, we find that the said order ought to be made absolute in order to save the appeal from being rendered infructuous. Full stop. Accordingly, can 1 of 2024 is allowed on contest, thereby directing the learned trial judge to continue with the final degree proceedings. Full stop. However, comma, no final degree shall be drawn up till disposal of the appeal without the prior leave of this court. Full stop. Next para, no order is to cost. Full stop. In view of the appearance of the respondent to his learned advocate, comma, service of notice of appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Please just ask the learned advocate to take a server copy and deposit the special messenger cost within a week. Yes, Mr. Hadi, what is the matter?
My lord, decree.
You're for the other side or with him?
No, with
You don't have to get so close to him. Don't have to prove anything. You can remain physically
My
apart.
lord, decree could not be drawn up, my lord. And there is delay of 57 days, my lord. Therefore, leave be granted, my lord.
You have to serve a copy on the other side. Section 5.
Definitely we shall, my lord. We shall.
There was no direction previously?
No, my lord.
Wait. The petitioner shall serve a copy of this application on the opposite party, indicating that the application shall be listed for hearing on April 9, 2025, when an affidavit of service to that effect shall be filed by the petitioner. Come back.
A typographical mistake in original order, it will be decree. First paragraph, memorandum of appeal.
Leave is granted to the learned advocate for the appellant to rectify the cause title of the memorandum of appeal appropriately during the course of the day.
Well, in the meantime, we are trying to get the decree be drawn up, my lord.
Achha, the appellant shall also file the certified copy of the impugned decree as and when the same is drawn up by the learned trial court. by the concerned department of the learned trial court. Correction, side. Yes, 21.
My lord, I appeal for the appellant, my lord.
Yes,
My lord,
please.
this is my appeal against an order dated 12th December 2024.
You have not deposited 4 rupee, Tolabana of rupees 4.
Oh,
Put
I'm
that
so
in.
sorry.
Put that in. We'll give you a week for that. We'll take up your application. What is the application for?
My lord, this is an application for stay of an order. My lord, the order rejects my plaint. I am for the plaintiff. Rejects my plaint on the ground that there is no cause of action. My lord, my submission is that there is a cause of action. There is admittedly there is an agreement for sale which the plaintiff is seeking to enforce. What the learned judge has done is that, my lord, may I just in a nutshell give my lord history of this litigation, my lord. This is an agreement of sale entered into between the plaintiffs and the defendants. I am for the plaintiff. The appellant is the plaintiff before the learned judge. My lord, this is an agreement of 2019. 11 lakhs rupees is paid as earnest money deposit. The deposit is accepted till 2021.
By the defendant?
By the defendant, my lord. My lord, thereafter, I came to know that the defendant is trying to alienate the property. I file a civil suit. Thereafter, the defendant firstly comes up with an application under Section 5 of Limitation Act saying that the suit is barred by limitation, that proper court fees has not been paid.
Section 5 of limitation?
Yes, my lord. That is their application. That is what they have preferred.
Yes.
That application is dismissed. And my suit is held as not to be barred by limitation. Thereafter, immediately thereafter, they file an Order 7 Rule 11.
Be prepared for, after this is over, be prepared for the Order 14 Rule 2 application. Anyway, so that is the usual modus operandi in this case. You understood.
But on the second, after the Section 5 is rejected, they again file an Order 7 Rule 11 saying that proper court.
What about this no specific date mentioned in the plaint, not in the alleged agreement pertaining? Oh, in the agreement, if it was not mentioned, how can you mention?
No, my lord. What has happened, my lord? The date of the agreement is there. The price is also decided as per kata. The land is also clearly demarcated. And it is my submission in the plaint as well as it will appear from the agreement.
He has gone into the merits apparently.
Yes, my lord. He has admitted there is a sale agreement.
You serve copies of everything, lock, stock, barrel, application. There are how many? One application only.
Yes, my lord.
Serve a copy of this application and the memo of appeal. On how many respondents are there?
My lord, there are
4. Who filed this Order 7 Rule 11? Only one.
Only respondent number 1.
We'll dispense with on the others. Serve on respondent number 1. Come back. We'll make it clear that we'll hear the appeal and the application on the basis of the papers. You have annexed the plaint.
Yes, my lord. Everything is
711 is there.
Plaint. First 711, second 711. There are two.
First was Section 5, you said.
No, there's a Section 5. There is a 711.
What happened to the first Section 11?
Both dismissed, my lord. Section 5 is filed, dismissed.
Section 711 was first one was dismissed on what ground?
First one is this was alleged that there is court fees improperly paid. Court said that look, I have already dealt with.
Now 711 on a different ground.
No. Now may I just take a moment? Section 5 is filed, then Order 7 Rule 11 is filed. It is dismissed on the ground that you have already made all these arguments in the Section 5 application. We have dealt with it. We are not going into it. They prefer a civil revision before this honorable court. Court says that I agree with the part that it is not barred by limitation, but as far as court fee is concerned, only as far as court fee is concerned, please hear them again. Then instead of rehearing the same Order 7 Rule 11, they file a new Order 7 Rule 11.
So you have annexed all these things?
Yes, my lord. All of this except
yes, except Order of Revision.
Except the first Section 5 application is not annexed, but the order is there.
Did they file any objection? Did you file any objection to
yes, my lord. I have filed objections to all 3.
You have annexed those also?
Both objections to Order 7 Rule 11, both are objections.
The present appeal arises out of what is the purpose of stay? Stay does not mean anything. 711, the suit has been rejected. If you stay that, what happens? The suit will revive, will continue.
No, my lord.
There is no scope
that
of
should have been an injunction application, my lord. That because we were
there.
We were enjoying injunction for the learned.
Is there any averment of injunction? There, you have to make specific pleadings that they are trying to do something. You have not asked for that.
No, my lord.
Not even in the prayer.
That is not there. I bow down to that. That is not there. But we were enjoying.
So we'll use this as a handle to hear out the appeal. That's why we'll keep it pending. Because if we dismiss it right now, we can dismiss it right now and give you liberty to file an injunction application. That will delay the matter. In the meantime, we should not advise you. You can do whatever you like regarding injunction. We'll direct this to appear along with the appeal together.
Grateful, my lord. Kindly.
The present appeal arises out of the rejection of a plaint in a suit filed by the appellants on the ground of non-disclosure of cause of action. Apparently on the ground of non-disclosure of cause of action. Full stop, next para. Since the relevant documents and pleadings are all annexed to the present application for stay, comma, we are of the opinion that in order to avoid unnecessary delay, comma, the trial court records be dispensed with. Full stop. We also dispense with the formal preparation. We also dispense with the preparation of formal paper books and decide to proceed with the hearing of the appeal along with the application on the basis of the papers already on record. Full stop. Accordingly, the appellants shall serve copies of the application as well as the memorandum of appeal on the respondent number 1, indicating that the matter shall be listed under the heading application on April 21, 2025, when an application affidavit of service to that effect shall be filed. Full stop. However, comma, it is made categorically clear that on the returnable date, comma, we will take up the appeal along with the application for hearing. Full stop. The appellants shall also serve a server copy of this order along with the application on the respondent, so that it is clear to them that we will take up the appeal.
Grateful.
Full stop, next para. Service of notice on the other respondents are dispensed with for the present. Full stop. The service of copies of the application along with server copy of the order as well as the memo shall be deemed to be sufficient service of notice of the appeal on the respondent number 1 as well.
Grateful, my lord.
10 মিনিটের appeal শুনে যাও। Non-disclosure নেই, disclosure আছে। No cause of non-disclosure of cause of action.
My lord,
Yes.
This matter, my lord, your lordship had given me liberty to file a second appeal, my lord. A second appeal to the counterclaim.
Acha, yes.
Yes, now, my lord, I have applied for the certified copy, my lord. It'll take some time. My lord will kindly give me 1 week's time. It is my appeal, my lord, and this is my state.
Are you enjoying any interim order?
No,
Then, Mr. Chakraborty, there is no difficulty. So when should you keep it? Tell us, Ms. Banerjee.
My lord, they are saying 1 week, but to be on the safe side, 2 weeks, my lord.
Very well. On the prayer of the appellant, comma, in order to enable the appellant to obtain a certified copy of the judgment and decree of the impugned judgment and decree of the trial court for the purpose of filing the first appeal, comma, let the matter stand adjourned till April. We'll give you 1 week more, April 16, 2025, under the same heading.
Keep you.
Yes, you are
Waiting for the respondents.
respond, right. All the respondents.
Yes, ma'am, all the respondents.
Right. Yes, Mr. Chatterjee, what is the matter about?
No, my lord, suit that was filed for declaration and recovery of possessions.
Oh, yes.
Based on a document. They say we have purchased from someone. My lord, a suit was filed against us.
You are described as a trespasser.
Hello.
You are described as a trespasser.
My lord, my position nobody knows because I'll explain everything, my lord. Now, what has actually happened, my lord? Kusum Products, they are actually originally the owner of the property. Now they inducted licensee. One of them was my father, another is vendor. Then, my lord, after demise of licensing, my lord, his son sold the property. The license is gone. On what basis? And so many mistakes in the deed. Well, at the time of hearing, everything will come out. Then, my lord, suit was heard ultimately. Suit was decreed. And very interesting thing is this, my lord. He submitted that, well, the date of cause of action is like this. I disposes actually prior to that. But he purchased after that. So many confusion. But anyhow, I have lost the case. I cannot deny that. And that's why I prefer an appeal. My lord has already protected me by granting a stay. And to serve at the people moving that we also serve notice, my lord, because it was lodged, one person's, my lord. Now they are appearing, they have used an affidavit. I have also used the reply.
For occupation charges.
My lord,
For occupation charges.
now kindly appreciate one aspect.
Yes.
Right from Attaram and others, Attaram Khacha Chada, right from Attaram, my lord.
Yes.
Yes. But there is basic and fundamental difference. As we know, my lord, that well, the precedent will apply, but I'll just cite right now only to show that, my lord, to distinguish that judgment of Supreme Court.
Yes.
Not because there is some sort of similarity. Here, kindly consider the case. I could have understood that, well, I was inducted by him, number one. No. I could have understood that, well, I paid rent or amount equivalent to rent anytime to him. No. He purchased from the heirs of the licensee, a license after demise of the licensee, and there was no relationship with landlord. Milos very rightly put this question. What was the status? Which then
What
all,
status do you claim?
well, I am actually inducted as a licensee by other persons.
And that is not been mentioned, my lord. Subject to correction.
In your defense, what did you say? In your written statement?
My lord, actually, I'm in position.
Licensee.
More than very interesting. I have filed an earlier suit. Declaration injunction. I expected that.
Declaration that you are?
Here I'm the owner by adverse possession. More than 40 years, I'm enjoying that.
What happened to that suit?
Very interesting. Admittedly, that suit was prior to suit filing this suit. I expected, I just inquired, why did you not file the application of stay section 10? Because everything is same. That was not done. Suit is still pending. In the meantime, hurriedly the suit is disposed of. So that suit is pending, still it is pending. I've been enjoying this property more than 40 years. My name is recorded, everything is there. Now regarding that payment of, can you see the one judgment? So my lord is my lord still. I am really very much eager to cite this judgment, my lord, regarding precedent.
Mr. Banerjee, give us half a minute. Yes. Yes.
Relationship as the landlord tenant. That's why Supreme Court very rightly said, you are enjoying this property. Maybe you are paper unhappy, but you have to protect. That concept was introduced. But here case is completely different. Kindly have a look. Of course, this is not the new thing. Earlier, my lord, even in 1964 and other Supreme Court, but very short, very precise. Kindly come to paragraph 14 or paragraph 13 onwards. Paragraph 13.
Yes.
The Home Office such. Then kindly Lord Morris observations.
Yes.
There is always peril in treating the words of a speech or judgment as though they were words in a legislative enactment. And it is to be remembered that judicial utterances made in the setting a fact of a particular case. Circumstantial flexibility. One additional or different fact may make a world of difference between conclusion of two cases. Disposal of cases by blindly placing reliance on a decision is not proper. The following words of Lord Denning in the matter of applying precedent have become locus classicus. It's really classicus. Each case depends on its own facts, and a close similarity between one case and another is not enough, because even a single significant details may alter the entire aspect. In deciding such cases, one should avoid the temptation to decide cases, as said by Cordojo, by matching the color of one case against the color of another, to decide therefore on which side of the line a case falls. The broad resemblance to another case is not at all decisive. Precedent should be followed only so far as it marks the path of justice, but you must cut the dead roots and trim up the side roots branches. You will find yourself lost in the ticket of unsensed. So, what I'm on, my lord, I could understood, yes, very rightly, my lord, with lots of experience from both sides, put these questions. What is your status? I am a tenant. Naturally, since the tenant suffer a degree, right from Attaram, in all cases, relationships doesn't exist, your supplementary degree you have to pay. But my case is completely different. So that case doesn't apply here. He never realized any money from me. I never paid him money. I filed a super declaration against the other owners for adverse possession since I've been enjoying for more than 40 years. I could have understood that well. He realized the money. Naturally, my after all, you paid the amount equivalent to rent. So now how can we have it? The case is completely different.
All right.
So this is the case where, my lord, since it's the first appeal, after Mulchand's case, when there is serious consequences, and my lord, in our High Court, there is no question of any admissions, my lord is kind enough to grant me the stay. Only thing is whether I am liable to pay any amount at this stage.
They have levied execution here.
My lord?
They have levied execution.
Yes, stay has been granted by your lordships, my lord. Stay has been granted.
Execution case has been filed.
I don't have the instruction, but fair enough, there no execution case has been filed till now.
Oh, then
one
No,
thing,
but we have stayed operation of the day. That's why.
can I get a copy of the order or the judgment, which he has cited?
और judgment reference दी दिलम तो.
ठीक है, तुम काम.
तो दी नहीं.
This is on precedent that a judgment can be a precedent on only what has been decided. It is settled time and again.
Only I wanted to show my lord.
Cannot place blindly, reliance blindly.
Yes. It is not the
setting of in the has to be read in the setting of facts of the particular case.
It is the fault of the
To
honorable
distinguish
judges.
Attaram and the others.
Yes, there is a series of judgment on this point. That's why courts are really have to pay. I said, no, in my case, probably subject to lawsuit sanction, my lord. I need not pay at this stage.
Well, so let us hear them.
As your lawsuits,
yes.
If you need any further inquiry, my lord, inquiry, sir.
There are two things, my lord, I need to bring to a lordship's notice, my lord. My lord, they have stated that there was no evidence, my lord. There were no witness. During the witness action, we have not given any evidences. But, my lord, these are the copies.
That is on the merits of the appeal.
Just, my lord.
We are just on the occupation charge part. Whether he is at all liable to pay occupation charge to you.
No, he is not liable. Subject to fair connection, he is not liable. My lord, neither he is he is liable to pay me any occupation charge. But, my lord, the property which is in question, my lord, that was purchased by me in the year 2001, my lord. That has already been annexed, my lord.
No, if you yourself submit that he is not entitled to any occupation charge, then we'll make this stay absolute without any occupation charge. We'll record your submission.
My lord, to record this. Now I have this instructions.
You have this instruction?
Yes, my lord. Not to record this. I'm not to record.
I will record this. Yes, we'll have to record this because we were thinking otherwise.
No.
I'm sure not young girl is there. He told me before.
Then why didn't you say at the inception? Why did you direct affidavit in opposition then?
Sir, before I came to say, Dadu nothing only. Dadu only.
My grandfather's friend is appearing against me.
That has no nexus with this. You cannot compromise the interest of your client because your grandfather's friend is appearing.
Absolutely not.
Anyway, since you submit that, we'll record
That was
that.
a candid submission which was made by me.
Learned senior counsel appearing for the appellant submits that no occupation charges are liable to be paid to the respondent. Full stop. Next para, it is contended that the line of judgments of the Supreme Court whereby occupation charges have been directed to be paid as condition of grant of stay, where in the context where there was landlord-tenant relationship between the parties, whereas in the present case, there was no juror relationship between the parties at any point of time. Full stop. Next para, it is submitted by learned senior counsel for the appellant that the said judgments, as such, do not operate as binding precedents in the present regard, for which proposition learned senior counsel cites the State of Rajasthan versus Ganeshi Lal, reported at AIR 2008 SC 690. Full stop. Next para, learned counsel appearing for the respondents, on instruction, submits that the respondents do not are not entitled to any occupation charges. Full stop. In view of such specific and categoric admission on behalf of the respondents, we are not entering into the question as to liability of the appellant to pay occupation charges for grant of stay in such cases. Full stop. However, we make it abundantly clear that this is not an adjudication on the issue because we have our doubts as to whether such issue can be uh, uh, such issue uh, because we have our doubts on the said issue on law. Full stop. Be that as it may, comma. Now, as hence, comma, we make it make it clear as well that we are refusing to grant occupation charges on the specific admission of the respondents waiving such right, and do not adjudicate on the question as to whether in circumstances at the present, comma, even if there is no landlord tenant relationship between the parties, comma, the appellant is liable to deposit occupation charges within the contemplation of order 41 rule 5 sub-rule 5 sub-rule order 41 rule 5 of the Code of Civil Procedure. Full stop. Next para. Uh, accordingly, accordingly, can 1 of 2025 is disposed of. আচ্ছা তার আগে একটা লিখে নাও affidavit in opposition and reply filed to be kept on record. Full stop. Accordingly, can 1 of 2025 is disposed of by granting stay of operation of the impugned judgment and decree till disposal of the appeal. Full stop. You are appearing for both the respondents. In view of the appearance of the respondents through their learned advocate, comma, service of notice of the appeal is dispensed with on the respondent, full stop, respondents, full stop. The trial court records shall be called for by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Who's of liberty to the parties to mention the appeal for inclusion in the list for hearing, as and when the same is made ready for hearing. Thank you.
My lord, I appear for the respondent number 1, my lord. My lord, my opposition is out of time, my lord. I have served them out.
You have filed it? Yes.
Yes, my lord, I am filing it, my lord.
The affidavit will extend for 2 weeks. The affidavit in opposition filed today be kept on record. Full stop. The delay in filing the same is condoned and the same is accepted. Full stop. Affidavit of service is also kept on record. Full stop. The on the prayer of the learned advocate for the appellants, the time for filing affidavit in reply is extended for a fortnight from date. Full stop. The matter shall next be listed on April 16, 2025 under the same heading.
Kindly keep.
Very well. Then April 21.
Great.
April 21, 2025 under the same heading.
Great.
Yes, Mr. Banerjee.
The original property, what question? In fact, I'm telling you about.
Yes, yes.
Original property belong to Devendranath Dotto. Devendranath Dotto died in jail.
What is the suit for?
For declaration that the deed of 1993 is a void document filed in 2005.
Suit is filed.
Lordship knows Article 50. Limitation, your Lordship judgment, thereafter so people. Consequence, he doesn't give for partition.
But if it's a void document, then there are certain judgments that there is no limitation. I mean, you can take up.
Declaration that it is a void. In the case of a void and voidable, both 31 applies. Lordship
Yes.
knows, they specifically that 31 applies.
Yes.
Now, Lord, in the case of void, in the case of setting aside document, 59.
Cancellation, yes.
59 setting aside document from the date of obtaining knowledge. Lord, may I place it?
Yes, yes. Limitation Act.
Limitation Act. 59, madam.
Here it is for declaration that it is void.
Void.
So 58 you are saying.
Lord, consequential relief is Lord for partition. And
The main relief is that.
And second question was,
yes.
Lord, second question was that Devendranath Dotto died. Lord, because Devendranath Dotto purchased the property admittedly on 25/2061. Marked exhibit, my lord. He acquired title by deed 25/1961.
Devendranath Dotto, who was he?
Devendranath Dotto, Lord, died, leaving behind his wife and son, one son. Now, Lord, plaintiff's case is that plaintiff is the daughter. Now, Lord, relationship, Lordship knows, my lord, that relationship is to be proved by a person having a special means of knowledge. Otherwise, all he has said. Number one. Number two, because of section 50 and section 32, subsection 5 of the Evidence Act. Persons having a special means of knowledge can prove the relationship.
Yeah, relationship. Did you raise a dispute regarding relation?
Yes.
How was the, how did?
My case is that he died leaving behind his wife and only son. And recital in the deed, Lord, 1993 deed, exhibit 5 and 6, both of Lord wife executed and registered a deed. Another son executed and registered a deed of settlement in favor of dependent number 2 and 3.
So daughter was ignored.
He said that he died leaving behind me, wife and son, only son. These recitals, my lord, is marked exhibit.
It is a judgment of affirmance.
Judgment of reversal.
Trial court dismissed the suit on these
Trial
grounds.
court dismissed the suit on this ground. Trial court said 32-5. 32-5, another thing, my lord, there was a bis case. Trial court said that in the bis case, order 39 rule 2A, bis case he stated about the relationship between plaintiff and and the plaintiff and the
Devendra.
Asarani. Plaintiff and Asalota. Asalota Bada.
Ashalata was the wife of Devendra.
Yes, wife of Devendra. Now, Lord,
Mother of Devendra or wife of?
wife of Devendra. Now, Lord, trial court proceeded on the basis of 32(5). Secondly, trial court proceeded on the basis of recital.
Evidence একটা দিন তো।
32(5).
How did the appeal court reverse? On what ground?
Lord, appeal court only.
No, limitation ground. It was dismissed also on limitation ground. Trial
No,
court.
no. Lord, limitation ground practically was not argued either before the trial court or before the appeal.
32(5) you are saying.
32(5). Persons having a special use of knowledge.
Yes. And 50.
And 50. Opinion of evidence, 111.
Right.
And my Lord, 60, oral evidence must be direct evidence. Lord, your Lordship kindly.
Yes,
come
that has to be.
If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. Now, my Lord, hearsay is not admissible, but if hearsay is from a direct person who is having a special means of knowledge, then, my Lord, he comes within the purview of 60. That is, my Lord, in Dol Govindo case, Supreme Court.
He has who has adduced evidence? The daughter.
Daughter did not come forward.
Who came?
Blood, his son, 25 years came.
Daughter's son came.
Daughter's son. That
The
is
plaintiff's son came.
Plaintiff's son came.
So he could not have direct knowledge.
Yes, cannot have any direct knowledge. And no, my Lord, every witnesses having a special means of knowledge has come forward to adduce evidence. Therefore, Dol Govindo, my Lord, is the authority on the subject. I have brought Dol Govindo also.
The present second appeal will be heard on the following substantial question of laws. Substantial questions of law. Roman 1. Whether the learned first appellate judge substantially erred in law in not dismissing the suit on the ground of limitation in view of the principal relief sought in the suit being declaration that a deed of 1993 is void, whereas the suit itself was instituted in the year 2005, by conjoint application of Section 31 of the Specific Relief Act 1963, as well as Article 58 of the Schedule to the Limitation Act 1963. Roman 2. Whether, in view of the relationship between the plaintiff and late Devendra, within bracket daughter hyphen father bracket closed, having not been proved in consonance with sections 32 within bracket 5 and 50 of the Indian Evidence Act, the learned first appellate judge erred in law in decreeing the suit on the premise of such relationship. Next, Roman 3. Whether the evidence of the son of the plaintiff, who was at the relevant point of time, who was at the time of deposing about 25 years of age, could be relied on by the learned first appellate judge, in view of the said witness having no direct knowledge insofar as the relationship between his mother, the plaintiff, and her alleged mother, the plaintiff, and her alleged father, Devendranath Dotto, is concerned. Any stay application?
Injunction application.
Yes, there is no scope of stay actually. Injunction application.
Injunction can 1 minute. Transfer and convert the property.
Very
Because court said that the plaintiff and the defendant number one is the owner of the property, partition degree has been passed. Lord, I am entitled to because I have I got the property
very well.
from both of them.
The only against the plaintiff respondents.
Only against the plaintiff respondent.
The plaintiff respondents numbers 1 and 2 are hereby restrained by an order of injunction from selling, transferring, alienating, encumbering, and or creating any third party interest in respect of the suit property till disposal of the application. Full stop. The appellant shall serve copies of the application on the respondent numbers 1 and 2, indicating that the application shall be listed before the appropriate learned single judge, subject to being mentioned by the parties. Full stop. Next para, an affidavit of service shall be filed by the appellant in that regard before the said learned single judge, having determination at the relevant point of time. Full stop. Service on the respondent numbers 3 to 5 is dispensed with for the present.
But I may be permitted to incorporate a prayer to stay the further proceeding of the suit because preliminary decree has been passed between the suit and defendant number one. That is the reason.
A leave is granted to the appellant to file a further application, file a separate application for stay of all further proceedings of the. You want to incorporate that prayer here?
Incorporate that prayer.
Very well. Article and Atkoda on the prayer of learned senior counsel appearing for the appellant, leave is granted to the learned advocate on record for the appellant to incorporate an additional prayer of stay of all further proceedings of the suit in the prayer portion of the present application. Such necessary consequential amendment to the prayer portion shall be carried out by the said learned advocate on record for the appellant during the course of the day. Next para. During pendency of the present application, the learned trial judge shall proceed with the final degree proceedings. Semicolon. However, no final degree shall be drawn up prior to the leave of this court. At this stage, very well, we are directing. But if they appear, then service of notice we can dispense with.
Yeah. At that time.
At that time, the prefer.
At that time, it will be better.
I think it will be better. It will be a composite order. Composite, yes. Let it be then.
And your lordship judgment on 58, my lord, that has been practically the same tune, my lord, in 44 cases by the Supreme Court.
I don't recollect.
2020 Supreme Court, 44 cases.
I don't recollect my judgment. Anyway.
I know lordship judgment I have to. And Supreme Court has been.
In some other matter.
Item number 26.
Yes.
26 is my appeal, my lord.
What is the defect, Mr. Mukherjee?
My lord, I think that was for short deposit of the court fees.
Just let us check up.
Application has been filed. That can be regularized. Because so far as the order 41, I would be praying for an accommodation for today.
No, you have put in the deficit court fees.
Yes, I have already put.
Beyond time. So you will accept that.
You accept that? I have also filed an application to that respect, can too.
So they will allow that application and accept that. And name of defendant numbers 3 and 4 in the decree of trial court, neither in the appellate court degree nor in the cause settle. What happened to them?
Lord, that I am not very sure.
Erroneous. It has been reported that the appeal court's degree should be sent down.
After admission, that can be sent.
But you have to incorporate the names of those two persons in your appeal.
That I will do. And if it can be kept tomorrow.
This is a second appeal.
This is second appeal.
No, we can hear you right now. We'll.
Lordship, kindly keep. So for the admission hearing is concerned, my prayer is kindly gives me an accommodation for the day.
Why?
I am led by Mr. Probal Kumar Mukherjee and.
We find from the report of the additional stamp reporter that deficit court fees, although belatedly, have already been deposited. Full stop. We accept the said deposit on condonation of delay in making the same. Full stop. Next para. Leave is granted to the learned advocate on record for the appellants to incorporate the names of the defendant numbers 3 and 4 in the court below as respondents in the present appeal. as respondent stroke pro forma respondents in the present appeal, because you are also defendant. Full the necessary consequential amendment to the cause title of the memorandum of appeal in that respect shall be carried out. Memorandum of appeal as well as the connected application shall be carried out by the learned advocate on record for the appellants during the course of the day. Next para. On the prayer of the learned advocate for the appellants, comma, the matter is adjourned for the day and be listed tomorrow under the same head.
I'm up.
I'm for the appellate.
Yes, Mr. Pal.
So actually, I have challenged the order, Lordship. My property has given private respondent has executed power of attorney of my property, Lordship, and that I have challenged before the
private respondent executed power of attorney of your property.
My property, Lordship, and that I have challenged, Lordship. But the Lordship order is it in memo of appeal, Lordship.
Yes, but what has been done? Injunction has been application has been dismissed or identity refused?
No, Lordship. The order says that
Identity refused.
Defendant and come and they are.
So what is the ground for refusal?
Lordship, refusal means refusal grounds. There is no as such. There is no ground.
Let us come to page 2, the second paragraph.
Lordship.
Please from there, Mr. Paul.
Lordship, peruse the petition filed under Order 39, Rule 1 and 2 of CPC, along with all the documents upon which the plaintiff relied upon, and on perusal of the same, I find that late Satyanaran Dalmia and his wife, Munni Devi, adopted one Jogendra Kumar Dalmia, the father of the defendant number 1 and 2, and father-in-law of defendant number 3, and grandfather of defendant number 4. And after the demise of Munni Devi, Satyanaran Dalmia married one Bhagavati Devi Dalmia in the year 1949. And due to the said wedlock, one biological son, namely Santosh Kumar Dalmia, was born, who is posthumous child, and as Satyanaran Dalmia died on 16 June 1950. And the plaintiff Santosh Kumar Dalmia was born on 29th August 1950. And at the time of his death, Satyanaran Dalmia left huge properties which spread different parts of Haryana and West Bengal. In the year 1953, the legal heirs of the said Satyanaran Dalmia, namely Bhagavati Devi Dalmia, Santosh Kumar Dalmia on one side and Jogendra Kumar Dalmia on the other side, filed a title suit being such and such number. When it was declared that Jogendra Kumar Dalmia is a legally adopted son of Satyanaran Dalmia, and that Bhagavati Dalmia, Jogendra Kumar Dalmia, and Santosh Kumar Dalmia are each entitled to an equal share in the property left by the said Satyanaran Dalmia, and that the property shall not be partitioned till the said Jogendra Kumar Dalmia and Santosh Kumar Dalmia attain majority, and subsequently suit number such and such was settled in the High Court at Calcutta on the ordinary jurisdiction on such and such date, and the property was amicably distributed between the parties, which is revealed from the documents as page number 27, 28, 29 of the annexure filed by the plaintiff. And I also find that one power of attorney was executed in the year 1988 by the Bhagavati Dalmia and defendant number 1 and 2, and husband and father of defendant number 3 and 4 respectively, in favor of the plaintiff. And subsequently, after the demise of Rakesh Kumar Dalmia, that is husband of father of defendant number 3 and 4, respectively, another general power of attorney was executed by all the 4 defendants, nominating defendant number 5 as the lawful attorney. It will not be quite proper to pass any order without giving an opportunity to other side to appear before the court.
There is no reason practically.
No reason.
But please convince us on the merits. I mean,
Lordship, kindly
you say that you had title in the property, but you are not a signatory.
Initially, what power of attorney given by the defendant?
Yes.
In favor of me.
In your favor, yes.
Lordship, after that,
that was regarding what? Their share of the property.
Entire property.
To do what?
To do anything, to sell, mortgage, anything.
Very well then.
And after that, Lordship, without cancelling that, one person was died, and his legal heir executed another power of attorney with the other persons in favor of third party. Wherein my property has been mentioned here. What is my property? Where is my property situated? Where is private respondent?
So the first power of attorney must have been regarding their share of the property.
Entire property.
No, you don't need a power of attorney regarding your portion of the property.
No, actually what happened, Lordship, there is no document, but there was a verbal settlement that entire property will be belongs to myself and my mother. And against that, they are taken some money. But I am not on that at this stage.
No,
but
the moment you say that all the others executed a power of attorney in your favor, then you cannot say in the same breath that it is your property also. Because if you are the owner,
my property and their property. All
For
property.
your property, how can they execute a power of attorney?
My mother was there. So my mother executed the property, my mother's property share and their share.
That is what you are saying. So your share, regarding your share, no power of attorney was initially executed.
No.
But subsequent power of attorney,
Executed.
without, first of all, regarding their share also, without cancelling your power of attorney, and regarding your share also.
Share and my mother's shares also.
What injunction did you seek?
Lordship, I am restraining them not to act on the basis of that such power of attorney, Lordship.
The detail of the power of attorney, where do we find in your prayer?
Lordship. Lordship, first power of attorney, Lordship.
Let us see your prayer in the present injunction.
Lordship.
You have asked here for dealing with the properties, scheduled properties.
Lordship.
You have referred to prayer F of the plane, but individually not stated here. Where is prayer F of the plaint?
Lordship, schedule A, page 11.
No. Oh, achha, it is given. No, the power of attorney you have referred to.
Lordship,
schedule
power
F.
of attorney, first power of attorney, page 99, Lordship, which gives power to me, Lordship.
No, you seek a cancellation in terms of prayer F.
Lordship, that is power of attorney at
Page
page
34.
119.
Page 34 is that prayer.
Lordship.
Okay. The present challenge has been preferred against the refusal of ad interim injunction at the behest of the plaintiff stroke appellant. The case of the plaintiff is that by a prior power of attorney dated, what was your date, first one?
21st December 1979.
Dated December 21, 1979, comma, the defendants and the mother of the parties granted and appointed the plaintiff as a constituted attorney in respect of their shares of the property, However, comma, without cancelling the same, comma, upon the subsequent demise of one of the executants of the said power of attorney, comma, another power of attorney was executed in favor of defendant number 5.
Lordship.
In favor of defendant number 5, learned counsel for the appellant argues that apart from the said power of attorney being invalid due to non-cancellation of the prior power of attorney granted in favor of the plaintiff stroke appellant, which was still subsisting, comma, the subsequent power of attorney dated June 15, 2023 is also bad on account of the same having, comma, inter alia, comma, granted power with regard to a portion of the property which belongs to the plaintiff stroke appellant without the plaintiff stroke appellant being a signatory thereto. We find from a perusal of the impugned order that the same is prima facie devoid of reasons, and the only ground given is that it would not be quite proper to pass any order without giving opportunity to the other side. Next para. Accordingly, we find sufficient prima facie case in favor of grant of injunction. Hence, comma, the appeal is admitted on the grounds taken in the memorandum of appeal and shall be heard on the said grounds as well as the grounds as indicated above. The respondents are hereby restrained by an order of injunction from selling, transferring, alienating, and or dealing with in any manner and or creating third-party interests in respect of the properties as described in Schedules A and B of the plaint, as well as from acting upon the impugned power of attorney dated June 15, 2023, registered before the additional district sub-registrar, comma, ADSR Kasipur, comma, Damdam, and recorded in book number Roman 1, comma, volume number 1506-2023, comma, pages 184966 TO2, 184981, being number 150606347 for the year 2023, comma, till disposal of the application. The appellant shall serve copies of the application on the respondents, indicating that the application shall next be listed for hearing under the appropriate heading on April 21, 2025, when an affidavit of service in that regard shall be filed by the appellant. Post.
Lordship, one thing, Lordship, it is my mistake. First power out only 16th August 88.
প্রথমটা যেটা 79
Executed,
বলেছি
16
ওটা
August.
অগাস্ট 16
88.
1988
Much obliged.
থ্যাংক ইউ Yes, Mr. Ahmad.
Defendant number 2 and 3 are the appellants before your lordship.
Acha, there is no caveat.
The suit for specific performance of contract
Hmm.
against the defendant number 1. The defendant number 1, my lord, executed and registered the deed of sale in my favor, that is the defendant number 2 and 3, the appellant before your lordship, on 13th of August 2013.
Yes.
Subsequently, my lord, the plaintiff has filed the suit for specific points of contract, my lord, alleging that the defendant number 1 has executed a deed dated 6th of May 2013. That is prior to my deed.
Executed deed or an agreement?
No, deed of sale was executed but not registered.
Acha.
My lord, they have prayed for specific performance that it should be registered by the defendant number 1.
There was a foundational agreement for that?
No.
Then it's not a suit for specific performance as such.
Specific for to execute, but to register the deed of sale. They have prayed this, my lord, in the plaint. That suit was decreed in presence of the defendant number 1, contest on defendant number 1, but ex parte against the defendant number 2 and 3. My lord, I filed an application under Order 9, Rule 30. Since it was ex parte against us. My lord, that was dismissed on their application that the Order 9, Rule 13 is not maintainable as it has been contested by the defendant number 1. My lord, thereafter, my lord, I was advised to prefer the appeal. After conclusion of the Order 9, Rule 13 proceeding. There, my lord, 7 years lapsed. I filed the appeal.
How soon after the dismissal of the Order 9 13?
Immediately after, my lord.
Ah,
Dates
very
are, my lord.
So you are invoking Article Section 14.
My lord, that has not been accepted. Section 5 has been rejected. Consequently, appeal has been dismissed. Opinion of the court is, my lord, in this way, all the matters, blame will be upon the
The
advocates
present
and-
second appeal will be heard on the following substantial question of law. Whether the learned first appellate judge substantially erred in law in dismissing the application for condonation of delay in the appeal and consequentially the title appeal itself on the ground of limitation without taking into account the provisions of Section 14 of the Limitation Act 1963, in view of the pendency of the appellant's application under Order 9, Rule 13 of the Code of Civil Procedure for restoration, for recalling the ex parte decree passed in the suit in the meantime. This is the only ground on which you are admitting, because at this stage, what is the
application for stay of the execution proceeding as well as, my lord, for injunction not to disturb my possession. I have annexed the record of rights. These are in our name. And, my lord, I am paying the taxes and I am carrying on business over there. I have stated in paragraph 6, page 3 of the application.
My application for appropriate orders?
Well, two prayers I have prayed. One is stay of the execution, another is my injunction.
From the annex, from the annexures to the application, we are prima facie satisfied regarding the possession of the plaintiff in respect of the suit property. Moreover, in the event the property is transferred in favor of third parties and/or the impugned decree is executed in the meantime, the present appeal is at the risk of being rendered infructuous. Accordingly, there shall be stay of all further proceedings in other execution case number, other to O capital, E capital. Other execution case number 1 of 2024 pending before the learned civil judge, senior division, first court at Kontai, district Purbo Medinipur, till disposal of the present application, full stop. Moreover, comma, the respondents shall remain restrained by an order of respondents and the men and agents shall remain restrained by an order of injunction from disturbing the peaceful possession of the petitioners in respect of the suit property in any manner and or from changing the nature and character of the suit property and stroke or from creating any third party interest and or selling, transferring, alienating and or encumbering the suit property in favor of third parties, comma, also till disposal of the application. Full stop. The appellants shall serve copies of the application on the respondents indicating that the application shall next be listed before the appropriate division bench as a learned single judge having determination, comma, subject to being mentioned by the parties for inclusion in the list before such bench. Full stop. The appellant shall file an affidavit of service on the next returnable date before the appropriate bench. This much.
I'm good.
May I please, Your Lordship?
Yes, please.
The two appeals. 29 is the appeal against the parent order of ad interim injunction, and the second one against the extension.
Extension.
Parent order, I'm placing my.
Yes, yes, absolutely. That will be FMAT 159.
15.
Yes.
Defendants are the petitioner before appellant before Your Lordship in a suit for partition. My lord, the order imputes the order of injunction, ad interim order of injunction in the form of status quo has been challenged, my lord, entirely on the ground, but the order of ad interim injunction was granted beyond the scope of the final order of injunction that may be passed in the suit.
Why do you say that?
My lord, Your Lordship kindly come to, can you take the stay application? I will.
Yes, yes, we will have to do that because of the prayer.
My lord, there are two schedules of the property. My lord, Your Lordship will find in the cost schedule property, there are two DUG numbers. Your Lordship will find in the 5166 and 5169.
Cost schedule.
Cost schedule. Jaha hal 5166 and 5669 dage,
Yes.
71 decibel, within which 2 decimal. So Lordship and Your Lordship will find in the cost schedule property.
Which is a part of which? Ko is a part of ko.
Ko is a part of ko. And Your Lordship will find in the ko, there is, Your Lordship will find only one DUG, that is 5166. So Your Lordship, the plaintiff has the share in respect of cost schedule property. Apart from the cost schedule property, the other properties of the cost schedule, they don't have any right title interest. And that is not included in the part of the suit for partition. The partition suit has been, partition has been claimed in respect of cost schedule property. Your Lordship,
but cost schedule is not yet demarcated.
Lordship, kindly see the order of injunction as short for.
No, but then the entire property, unless the entire property cost schedule has to be demarcated from ko. Otherwise, at present, it's a co-ownership property.
My lord, the cost schedule property is separate plot of lands is there. It can be depicted, my lord, by the plot of lands.
So you say that at least regarding 5169.
Yes. That clarification must suffice, my lord. Otherwise, it is an undue hardship in respect of the co-sharers who are the co-sharers in the 5169.
But at present, the two properties are a conglomerate whole. It's a joint property. How can one, without demarcation, how can one distinguish between the two?
It can be depicted through Moja map also, my lord, because they have given a rough sketch map as well, my lord. In the
unless it is partitioned by meets and bounds.
You can see the injunction as prayed for in the final order of injunction. Their possession in respect of coastal property they wanted to secure, and in the identity order of injunction they have prayed for injuncting me from the co and both schedule property. You kindly come to page 30 and 31. So in that event, there.
No, but you just see this. Although this is not in aid of the permanent injunction prayer,
yes,
but this is in aid of the main prayer, the first relief claimed in the suit, partition. This is in aid
the
of
declaration, the partition, the
yes,
the allocation. And
right. Although it's in respect of separate DUGs, as of today.
But when it is separated by the plot of lands, the different DUG numbers are there. My lord, it is not that difficult to, my lord. When he has depicted, my lord, he knows very well what share he is, my lord. Otherwise, 51, Your Lordship, 5166.
No, difficulty we are telling you. In 5166 also, the other co-sharers have a right.
But the plaintiff don't have. The plaintiff don't have. 5169, the plaintiff don't have. The plaintiff can't injunct any of the co-sharers who are the owners of the 5169. It is undue hardship in respect of the co-sharers who are the owners of the 5169. When he has admittedly don't have any share over the dark number 5169, if the other co-sharers are injuncted on the instance of the plaintiff in respect of 5169, it is absolutely undue hardship.
But their prayer, first prayer is that
Declaration, yes,
ভূমি
yes.
বাদী দাবিকৃত
Then my lord, you would not have divided into two plots of land. You would have given the singular hodgepodge. Then 5168, 5169 is a hodgepodge of the partition suit. So there my share is. He has deliberately done it because
he's claiming his share on co by virtue of what? Any deed?
No, inheritance.
Unless there is partition, how can there be inheritance getting co only?
But because some of the portions of other portion that has been
Let us see the pleadings in the plaint. This is a peculiar prayer because how can he claim even title, exclusive title in respect
some
of
the portion has been, but they are amicably depicted and they have sold out, and they are recorded their name. It was, my lord, in the RS, it was 511.
Rather, if injunction was granted protecting his possession, we would be interfering. Because that would not be possible because you have a right over every inch also.
But status quo in respect of 5169?
Yes, because it's a joint property as of today.
And if your lordship will also find that in the record of right also in 5169, he don't have any.
No, record of right,
yes,
you know the answer to that also.
Yes, my lord.
You answer her.
That is not a...
That is not a good argument. But though we are not inclined to interfere, we'll give our reasons. The reason being that this is in aid of the first prayer, first relief.
But your lordship, the injunction prayer, if your lordship tally between the injunction...
Permanent injunction is different.
Is different. And
therefore, this is not in respect of the present injunction is not in aid of the first. Permanent injunction and temporary injunction may be different because once he gets partition, after that,
yes, his possession in respect
of that. Simultaneously, when partition is granted, possession in respect of that can be produced. So there may be a discrepancy between the two. We'll direct the injunction application to you. Have filed your objection.
If not, my lord, I shall file within 15 days.
15 days.
Then 10 days, your lordship.
File within a week. It will expedite the matter. We'll do that. The present challenge has been preferred against the grant of an ad interim order of status quo. Push of learned counsel for the appellant, one appellant or several? Appellants.
More than
appellants argues, the learned counsel for the defendant stroke appellants argues that the injunction in the form of status quo granted by the impugned order is contrary to the permanent injunction sought in the suit itself. Full stop. Whereas in the suit, in prayer kha, injunction has been sought in respect of the possession of the plaintiff, in the interlocutory injunction application on the basis of which the ad interim order has been passed, the plaintiff sought for injunction in respect of change of nature and character of the suit property. Push up next para. Furthermore, learned counsel for the appellant takes the court through the reliefs sought in the suit as well as the two different schedules, that is schedule Q and Kha of the plaint and the injunction application. First up, it is evident from the prayer portion, from the prayers of the plaint, that the plaintiff seeks exclusive title in respect of co-schedule property, which is comprised only of plot number 5166, whereas partition has been sought in respect of the entire property comprised of plot number 5166 as well as plot number 5169. Full stop. Learned counsel argues that since the plaintiff claims exclusive title only in respect of plot number 5166, the learned trial judge acted without jurisdiction and beyond the scope of the suit itself by granting status quo with regard to the other plot, that is plot number 5169. Full stop. Next para. Secondly, it is argued that the plaintiff has not sought for permanent injunction or status quo regarding change of nature and character of the suit property, even in the reliefs of the plaint, and as such, the temporary injunction uh, application went beyond the prayers of the suit itself. Full stop, next para. Insofar as the first issue raised by the appellant is concerned, we find that although the plaintiff has claimed exclusive title over the cost schedule property, in the same breath, the first relief of the plaint pertains to partition of the entire suit property, as depicted in cost schedule, which is comprised not only of plot number 5169 but also 5166. Full stop. Unless there is a partition, the entire property remains joint, despite the same being spread over different plots. And as such, without a partition by meets and bounds, every co-sharer has a right, title, and interest over every inch of the joint property. Full stop. As such, although the prayer made in the temporary injunction application might not be in consonance with the second relief sought in the plaint, that is of permanent injunction, it is definitely in aid of the first relief of partition, which encompasses both the plots. Full stop. Next para. Insofar as the disparity between the permanent injunction and the temporary injunction sought in the suit, the same ipso facto does not vitiate the prayer in the temporary injunction application. Full stop. Next para. The permanent injunction sought in the suit would be a natural corollary of the first relief, which is partition. Full stop. In the event partition is granted, the property would then stand demarcated, and an injunction and a permanent injunction protecting the possession of the plaintiff regarding the demarcated cost schedule property would be the appropriate relief. Whereas at the present stage, before such partition is effected, the unless the entire property is protected, the ultimate outcome of the suit might be prejudiced and irreparably injury caused. Full stop. Next para. As such, we do not find any error or illegality in the impugned order of ad interim injunction sufficient to justify interference. Full stop. Next para. However, we make it abundantly clear that all the above observations have been made tentatively in respect of the present appeal, which arises from an ad interim injunction order only, and shall not be binding at any further stage of the suit and or the injunction application, and it will be completely open to the learned trial judge to decide the injunction application as well as the suit independently on merits without being prejudiced in any manner by any of the observations made above. Full stop. Next para. In view of the above, FMAT 159 of 2024 and the connected application bearing CAN 1 of 2024 are, in view of the above, FMAT 159 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, CAN 1 of 2024 stands dismissed as well. Full stop. Next para. The respondent, the appellants, the defendants stroke appellants shall file their written objection to the injunction application within, we are giving a fortnight, that will be within a fortnight from date. Full stop. Next para. It is expected that the learned trial judge shall dispose of the injunction application as expeditiously thereafter as possible, positively by April 30, 2025. No rest to cost. Next. What about the other appeal? We'll just say consequential. Very well. একটা order record করো না এরপরে, sorry, it's our fault. No, my fault. Since FMAT for 436 of 2024 has been preferred against the extension of the ad interim order of injunction, which we have affirmed by the immediately preceding order passed in FMAT 159 of 2024, comma, as a consequence of the above order, comma, FMAT 436 of 2024 is also dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Sorry.
I'm appealing for the appeal.
Yes.
This is that matter, my lord. Last occasion, my lord has heard, my lord, the respondent, my lord. It was.
He's appealing for the rest. You're.
They're appealing,
1 and 2.
they're appealing for the bank, my lord. Now, the only point was that whether they have filed an 42, section 42 before the learned code below, my lord.
Now, this is against what? This appeal?
My lord, this is against an award, my lord. An arbitral award, my lord. We have filed a 34 before the civil court, my lord. They have filed a section 42 before the civil court for the dismissal, my lord. Now, my point was that, my lord, they have taken a point that section 9 was filed prior to filing of the section 34. Section 9 was dismissed, my lord, as a default, my lord, as we were not appearing in that part. And this submission was never been recorded by the learned judge.
What submission was
My lord, we were not appearing in that matter, and the matter was dismissed.
No, now you have challenged the section 34 dismissal on the ground of section 42.
Yes, my lord.
So how does that matter whether you were that was recorded?
It was filed, my lord, long back.
Section 40 Act, Arbitration Act in the 96 Act, Arbitration and Conciliation. Thank you, Onakat. Section 42 does not qualify it.
Yes, my lord. He says that the
presented or something like that. Let us just check.
My 34 was dismissed on the part of jurisdiction only.
Has been made in a court, that court alone shall have jurisdiction. Let us just see the impugned order.
It is annexed to the memo of appeal as well as the stay, my lord.
Absolutely right.
This is their section 9 application, my lord. It was dismissed for default. So it's this 42 does
An
not
adjudication on merits is not required for section 42.
Yes, my lord.
Only the presentation is irrelevant.
is enough. Sufficient, my lord.
The present appeal has been preferred against an order whereby the appellant's challenge under section 34, challenge to an arbitral award under section 34 of the Arbitration and Conciliation Act 1996 has been dismissed on the ground of lack of jurisdiction by invoking section 42 of the 1996 Act, comma, in view of an earlier application under section 9 of the said Act having been presented before a different court. Puts up next para, learned counsel for the appellant argues that the said application under section 9 of the 1996 Act was dismissed for default and as such not adjudicated on merits, hence, comma, section 42 ought not to be invoked. However, comma, we do not find any substance in such contention, comma, since the relevant juncture within the contemplation of section 42 is not the date of dismissal or the nature of dismissal of a prior application, but the presentation of the prior application before a competent court. In the present case, next para, section 42, comma, pertaining to jurisdiction, comma, provides that where with respect to an arbitration agreement, any application under the said part has been made in the court, comma, part P capital court, comma, that court alone shall have jurisdiction over the arbitral proceedings, and all subsequent applications arising out of that agreement and the arbitral proceedings shall be made in that court and in no other court. In the present case, comma, since the appellant himself had made an application under section 9 before a different court, comma, it is the said prior court which had jurisdiction and not the learned trial judge, not the learned judge who passed the impugned order. Accordingly, there is no scope of interference. Hence, FMAT 62 of 2022 is dismissed under Order 41, Order 41, Rule 11 of the Code of Civil is dismissed. Yes, under Order 41, Rule 11 of the Code of Civil Procedure. Consequentially, can 1 of 2022 FMAT 248.
The number has been changed.
62.
There were some defects, my lord, and
FMAT number 248 of 2024.
The appeal is under against the order under section 25 of the Guardians and Wards Act, referred by the husband. There is a delay of 147 days in preferring the application.
This is a section 5 application.
I have filed
This is appearing for the first time. We'll direct it to serve copy and come back. The appellant shall serve copies of the.
I have already sent the track report.
Was there any direction of court?
No.
Then you know.
No, I should not have.
No, if they appeared, we could have taken up. But since the appellant shall serve copies of Can 1 of 2024 on the only the respondent or pro forma?
Only respondent.
Why the pro forma respondent was? What is the?
The minor girl. That's why she was.
Oh, she's the minor girl.
The minor girl. One is the respondent mother.
Acha, shall serve a copy of Can 1 of 2024 on respondent number 1, indicating that the application shall next be listed on April 9, 2025, when an affidavit of service to that effect shall be filed by the appellant. Push up next para. Service of notice on the respondent number 2, comma, who is the minor. No, she has not been described as a minor. Please check up.
But it has not been stated here. But she's the minor.
Could we will give you liberty to.
Correct.
No. In the cost title.
In cost title, it should be there.
You please guide him.
No.
On the respondent number 2, comma, who is the minor daughter of the parties, comma, is dispensed with. Full stop. Liberty is granted to the learned advocate on record for the appellant to carry out the necessary corrections in the cost title of the application as well as the memorandum of appeal to reflect the representation of the respondent number 2, comma, a minor, comma, through her guardian. Just carry out. Represented through next friend. But please ensure in both the judges' copies, memo as well as
I'm for the appellate petition.
appellant respondent. Very good. You are for both the respondents.
Yes.
All two only. Yes. Yes. What is that?
Lordship, we
So,
have
Basu, please
already,
take your seat.
we have already exchanged our deed, Lordship.
You have exchanged
the deeds of copies, the disputed questions of deeds, Lordship.
We've forgotten what deeds.
Occasion, Lordship, directed to serve the copies.
This is what is the defect? Out of time. Section 5 has been allowed.
Section 5 has been allowed, Lordship.
So we are taking up under order 41.
Order 41, Lordship.
Yeah, what is the matter?
Lordship, at least, Lordship, the
Give us the short
appellant-
facts. Yes.
Short facts, Lordship. The appellant purchased 36.77 acre or 36.
Now, first to tell us, you have challenged what? An ad interim refusal of injunction?
Ad interim refusal of injunction, Lordship.
Very good. So you purchase a plot?
It's a
final no,
not sorry, final order.
After
of injunction.
exchange of affidavits. Final then.
Final order of injunction.
Refuse and prayer in yes, right.
Actual fact, Lordship, that the ISCO appellant, Lordship, purchased total land of 36.77 acre in the name of 6 proxy purchasers, Lordship. The plots are
ISCO purchases in the name of
proxy purchasers. The Benami transaction, Lordship. They are
why are you not hit by
six,
Benami?
Six proxy purchasers are the Lordship.
They cannot be relatives of ISCO.
No, actually, Lordship.
Maybe relatives of Mr. Kollol Basu, but not.
Actually, Lordship, the ISCO has been merged with the SAIL Steel Authority of India in the year 2006, Lordship.
Right.
But the deeds had been executed, Lordship, in the year 1956 and 57, Lordship.
All right.
Oh, Lordship.
No, but if we dismiss the appeal, then we won't hear you, Mr. Basu.
Milord, the factum of merger, Milord, is not disputed, Milord. That is admitted.
Merger between whom?
Between the ISCO and Milord, the SAIL.
So you have described yourself as a unit of.
Yes, erstwhile the ISCO, Milord. Unit
so
of.
SAIL should be the appellant here.
Yes.
But here ISCO is the appellant.
Milord,
ISCO is the plaintiff also. You have
yes.
The suit is not maintainable. And moreover, you have said an unit. So on both counts, Mr. Basu, your suit should be dismissed.
This is Milord.
If ISCO has filed a suit as a unit of Steel Authority of India, The suit is not maintainable.
My lord, in the plaint also, my lord.
Must be this.
Yes, my lord.
So injunction was granted, refused on that ground.
No.
What is it? Anyway, please.
Yes. My lord, my lord, in the year 1956.
Yes.
My lord.
Benami purchases,
Yes.
36.77 acres.
Yes. My lord, we are concerned with CS plot number 4472 corresponding to RS plot number 6615, 6616 and 6617. And my lord, today, this particular, we are also concerned with, my lord, two persons, my lord, name of the proxy purchaser, my lord, that is the Pradyut Kumar Chatterjee and my lord, Kamal Banerjee. Now, my lord, the land that was purchased, my lord, in the year 1956 in their name, my lord, that was, my lord, amounted to rupees, that the area of the land is, my lord, purchased by Pradyut, my lord, 2.5 acres, which is, my lord, synonymous with, my lord, 215 decimals. Out of 215 decimals, my lord, the Pradyut Kumar Chatterjee, my lord, had transferred to his wife, my lord, 30 decimals, Purnima, my lord, 30 decimals of land, my lord, 1971. But in 1973, my lord, Pradyut Kumar Chatterjee, my lord, the erstwhile employee of our concern, my lord, he had executed a deed of release in favor of this, my client.
A registered deed of release.
Yes.
Regarding the entire property. After having transferred to Purnima.
Yes, my lord.
Transferred to Purnima was by a gift deed.
Yes.
Registered. So how could it release the other portion?
Because that is, my lord, that is the fact. And my lord, the fact is, my lord, out of 215 decimals, 30 decimals, my lord, this land, 30 decimal lands out of 215, this was transferred to Purnima. And this is, my lord, in respect of RS Dag number 6615. And my lord, further, Pradyut Kumar Chatterjee, my lord, had executed a deed of gift in respect of 68 decimals under RS Dag number 6616.
When? To Purnima on the same day?
To Purnima, same.
How much?
66 decimals, 68 decimals. So, my lord, total lands, 98 decimals. So, first one, 30 decimals, 6615. And my lord, 68 decimals under RS Dag number 68 decimals. Total land, my lord, in his possession, my lord, the ownership was 215 decimals.
How much remains? 117?
117.
117 remains, yes.
Now, my lord, Kamal Banerjee, my lord, the land was purchased, my lord, 6.66 acres. That is, my lord, 666 decimals. And out of, my lord, 66 decimals, he transferred to, my lord, Pranab Kumar Chatterjee by way of a sale deed in the year 67.
How much?
280 decimals, 218 decimals, 218 decimals correspond under, my lord, the land comprised in RS Dag number 6617.
What was the total land sold by him? You also sold
total, my lord, total, my lord,
218 plus?
218 total land.
Very well.
Out of 666 decimals.
He also did execute a deed of release again in your favor. In 1973 or when?
In 1973. Now, my lord,
those deeds of release won't have any effect regarding the already transferred portions.
Yes.
218 and 117.
Correct.
So,
my lord, we have also not questioned, my lord, those deeds.
You are claiming title in the suit regarding the remaining portion.
Yes, remaining portion and injunction, my lord, there was an element of encroachment. And, my lord, this fact of, my lord, deed of gift executed, my lord, in the year 1967, my lord, this was not brought to the, my lord, we did not have that knowledge, my lord, while, my lord, the plaint was filed.
1967?
This is, my lord, the first, my lord,
you said 71.
No, sorry, sir, the 71. Sorry, I'm sorry, my lord. The
so,
date is
Mr. Bose, then in this suit you have claimed for your title in respect of the entire property.
Entire property, my lord.
On the strength of the deeds of release.
On the deeds of
registered deeds of release.
Registered deeds of release. So, my lord, admittedly, my lord, and not only that, this.
Why was injunction refused?
Injunction order.
Ad interim was granted initially.
No.
You did not enjoy ad interim injunction initially.
10/5/2018, my lord, I first lodged the FIR that there is an element, there was an encroachment. Kindly see, my lord, what is the reason, my lord, that weighed with the court below.
Heard both sides confused. That is our plight. That's it.
Oh.
Because of your 66.7 and 33.2 and all unnecessary details.
Unnecessary.
Yes.
আরে এইসব জাজমেন্ট ওনাকে দেখে লাভ নেই, জানে সব।
You want to complicate further, you do, but
No.
at your own risk.
No, I'm not lending my ears.
Particularly mathematically,
not-
we are very poor.
No. Briefly, plaintiff's case is that the sub property was purchased by virtue of 8 separate registered deeds of sale by Pradyut Kumar Chatterjee, Kamal Banerjee, Josna Devi, Alokananda Mitter, Lakshmi Chatterjee, and Purita.
Grounds given. One is that they have deeds of title in their favor, and another is legality of deed of release.
Yes.
They challenge legality of deed of release on what ground?
Because, my lord, the deed of release, my lord, because this fact was not brought to our notice that before the deed was released was executed, my lord, this deed of gift was there. So we were under impression that the entire land by virtue of this is the fact.
And what about the other portion? They are claiming deeds of title. Who executed deeds of title in their favor?
My lord, the legal heirs of Pradyut and my lord Kamal Banerjee. এটাই তো বলছি লিগাল এয়ার্সই তো করেছে প্রদ্যুৎ পূর্ণিমারও লিগাল এয়ার্স করে পূর্ণিমা নিজে করেছে Milord Pradyut had executed this deed of gift in favor of his wife, no?
No, they are claiming on the basis of adverse person. They say open uninterrupted person. Trial court records in the first page.
Yes. But the fact remains, my lord, that this particular portion of the land, my lord, that was executed in favor of, my lord, the Purnima and the others, my lord, Shubhra, my lord, that is way back in 71. Right? And one is 94 former, the first one is 1971 and the second is 1967. And my lord, 67.
They have said also that in 2017 deeds were executed in their favor. Who executed the deeds of
the heirs?
heirs of Pradyut and
no,
yes, Pradyut was there in the management who acquired the property on his own. Thereafter, Malad, by way of a gift deed, he transferred it to his wife in 67. Wife thereafter transferred in my favor in 2017.
Wife, in respect of wife, only 30.
No, Malad, there were 2 deeds of
Total
2017. I get 98 decimals.
Oh, so you claimed regarding those portions which are transferred to the wife?
Yes, I claim from the wife.
From the wife.
Yes.
That 98.
Yes.
So regarding that 98, they cannot have an injunction in any
have any injunction. So far as Kamal Banerjee is
Mr. Basu, although at the order 41 stage, since it's an injunction, if you can decide the appeal itself. So that's why you are hearing him also. Yes.
Yes. And so far as Kamal is concerned, when Kamal Banerjee is concerned, he transferred it to one Pranab Chatterjee who died, and thereafter his heirs transferred it.
So you are claiming Pranab's, the portion only transferred to Pranab?
Yes.
By Kamal?
Yes. 130 decimals.
So Kamal was one of the culprits here.
Kamal and Pradyut.
Yes. So regarding that portion, what is the injunction sought by them?
Milord, restraining them, Milord, from interfering with our possession. And
I am in possession because eviction has been claimed.
What is the plaint, Mr. Basu?
Not if
the plaint
page
was
18.
180.
Now one page is missing.
The main page, the relief page.
Yes, yes. I have the
Basu, yes, the first 2 reliefs are not there.
Yes.
The primary reliefs in the suit are not there.
But the reason why
and you must have prepared yourself without that. You can understand the level of preparation also then. We hope Mr. Basu, are your clients in court?
No.
Or today we don't nowadays we don't know. Yes, anybody can be in court. Yes. So what about the first 2? You don't even know the first 2 reliefs.
But I was asking my junior to kindly pray for
the other Mr. Basu, do you have any copy of the plaint?
I don't have. But
you can read out A and B.
But I don't have, because whatever.
So how do you know eviction?
Because there is an averment in the body of.
Yes, mandatory injunction. No, they have also claimed to remove all construction and vacant person, to hand over vacant. That is D, which is there. So you are admitted in possession. Mr. Basu, this is contradictory relief.
Yes, madam.
Because
Prayer A, so far as the first relief is concerned, I'll just read it out. To pass a decree of declaration of title of the plaintiff company over the suit property, holding that the defendants have no manner of right to enter into the suit land, disturbing the peaceful and lawful possession of the plaintiff.
suit land comprises of the entire property, including your portions.
Yes.
Milord, so far as the portions that has already been, Milord,
Transferred.
they transferred to them, Milord.
No, let him complete. Mr. Basu, just yes.
Yes. And my lordship will kindly see the schedule. My lordship will see the plate starts at page 18. My lord, the schedule is at page 23.
Yes, is entire.
Yes, entire. My lord, so far as
Entire or 30 only. 30 was the amount, the portion transferred to you probably.
Yes, I'll just indicate. My lordship says tag number 6615 and
Yes.
6616.
Yes.
6615 and 6616 was transferred by Produt to Purnima in 1967.
Both of these, the entire thing.
Yes, 6615 and
Oh,
6616.
they restrict their prayer to the transferred portions only.
Yes.
At least regarding those two plots.
Yes, at least those two plots.
Ah.
I have been conferred, my lord, 98 decimals in 6615 and 6616.
So this is the entire, that is the entire property.
That is the entire property. And the other one is from Komal Banerjee. He transferred it to one Pranab Chatterjee who died, and thereafter his daughter Shubhra has transferred to Payal Malad, the defendant, by 2 registered deeds in 13th of September
That is
27.
in respect of 2.18 of 6617.
Yes, that is in respect of dag number 6617.
That is 2.18, the total amount of.
Yes, 130. What I have got is 130.
So not 2.
Yes, one of the balance, Malad, I am not concerned. I am only concerned with 130 decimals obtained from Malad Pranab Chatterjee and 98 decimals from Malad Pune.
You produced photocopies of your title deeds with your written objection in the court below.
No, Malad, that we have. We had filed it by way of.
You can you do have it with you now.
Yes, we have copies of.
No, keep it with you for the time being. So.
Milord, so far as this.
Yes, Mr. Basu.
Yes, Malad, this is the certified copy of the plaintiff.
Plaintiff. But then the suit property is comprised entirely of your purchased property.
Yes, because
if not the other portion.
Not the other portions. If that is the case, then Malad, the plaintiffs have already transferred it to someone else whom I have purchased in 2017. Because the deed of release could not have been executed because the person who executed the deed of release did not have title when it was.
The deed of release could not be executed in respect of this subject property.
Yes.
The rest of that entire property
Yes,
we can. So, Mr. Basu, then the trial court has refused on 2 grounds basically.
Because the schedule also, Milord, it covers, Milord, their property.
And Milord, I was yes.
One is that deed of release, exactly. Both grounds are valid. They have title deeds, and those deed of release regarding these properties.
This deed of
No
release
interference,
ultimately,
Mr.
Milord,
Basu. No interference. Probably you are also convinced by now. There is no scope of interference.
So far as the other party is concerned.
And you have asked for injunction, a mandatory injunction that admits their position, and eviction. And eviction also. So in the same breath, you are asking for mandatory injunction, asking them to remove construction, if any, and to hand over vacant possession to the plaintiff company. And you say, you ask for injunction, restraining them from disturbing your possession.
We proceeded on the basis of the previous deed, Milord, when this was done.
Whatever you proceeded on the basis of. Prayer A is declaration of title.
Yes.
C is injunction that they may not disturb your possession in respect of the suit property. They may not come into the suit property. And D is so that they vacate the suit property.
Yes,
Plaint should be rejected. You are doing it right now to help you from further agony and you file a fresh suit. Appellate court can also reject plaint.
Yes,
We are not appellate court as such, but from in a misappeal also. Why shouldn't you reject the plaint? It is not maintainable in its present form. We will grant you liberty to file a fresh suit on the self-same cause of action in any event, order 7 rule 11. No. You will file the fresh suit tomorrow. Anyway, we are not rejecting the plaint, but this is sufficient advice to your adversary.
Only Milord, kindly take it up tomorrow.
No, Mr. Basu. We have heard it at length. After that,
I just for the do we mention Milord, order, Milord?
No. We'll forget that. I have a habit of forgetting, and so many matters will come and go in between. No. We're dismissing it right now so that we can add another feather to our cap. By the impugned order, comma, a temporary injunction application filed by the plaintiff appellant has been dismissed. Full stop. Next para, learned counsel appearing for the appellant submits that in view of Benami transactions having been effected in the name of employees of the plaintiff stroke appellant, comma, which employees subsequently executed registered deeds of release in favor of the plaintiff company, comma, the plaintiff has title to the property. So as such, comma, the learned trial judge acted without jurisdiction and illegally in refusing temporary injunction. Full stop. Next para. However, comma, we find out upon perusal of the documents and upon hearing learned counsel for the respondent, comma, that the entire suit property was transferred by the admitted purchasers of the property, that is namely Produt and Kamal, within bracket, although claimed to be Benamdars of the plaintiff, bracket closed, comma, in favor of the defendants, comma, either directly or through the successors in interest of such purchasers. Full stop. Next para. As such, comma, we find that prima facie the defendants have been able to prove their title and possession in respect of the entire suit property. Full stop. Next para. In fact, comma, the deeds of release, comma, even if executed subsequently by the original purchasers Produt and Kamal in favor of the plaintiff, comma, would be toothless in view of the transferors having no title in the property at that juncture in view of prior transfers in favor of the defendants. Full stop. Next para. That apart, comma, we also prima facie find from the reliefs claimed in the suit that in the same breath, comma, the plaintiff has sought for permanent injunction restraining the defendants from disturbing the lawful and peaceful possession of the plaintiff over the suit property in relief C, whereas in relief D, comma, the plaintiff has claimed mandatory injunction directing the defendants to remove all construction, if any, from the suit property and to hand over the vacant possession of the suit property to the plaintiff. Full stop. Ex facie, comma, such reliefs are mutually exclusive and contradictory to each other. Full stop. The very prayer of eviction stroke mandatory injunction nullifies the claim of the plaintiff of being in possession of the property and as such precludes the court from granting any injunction to protect such alleged possession. Full stop. Thus, comma, we do not find any illegality or irregularity in the impugned order. Full stop. Accordingly, FMAT 382 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2024 is also dismissed. Full stop. There will be no orders to cost. Full stop. It is made clear that the above observations have been made prima facie for the purpose of deciding the appeal and will not prejudice the learned trial judge at any further stage of the suit on merits. Next appeal will be against the Order 7 Rule 11. Yes.
Okay, may we take back the certified copy of the plaint?
Yes, yes. The plaintiff certified copy যেটা উনি হ্যান্ড ওভার করে দিন ফেরত দেখে নিন ওনাকে একবার। Yes.
My lord, item 34, my lord, I am appearing for the appellants, my lord. I mean, led by Mr.
You are for the
Joy
respondent?
Gupta.
Yes, my lord. Mr. Gupta is in some difficulty. He has left.
Mr. Gupta is in some difficulty, my lord.
Very.
If it could be just not today, my lord. I'm just
Yes,
seeking
yes.
not today.
On the prayer of the appellant, let the matter stand adjourned for the day.
Grateful.
Lordship, I am for the respondent number 1. Lordship, I am.
So both are represented. Yes. Let us hear Mr. Bose.
Lordship, I am led by Mr. Senior Advocate Mr. Jishnu Chaudhary in this matter. He's stuck in another court.
In this matter, as my lord sees, I think, my lord, this is an appeal emanating under section 58 of the RERA.
Oh,
My lord, I find there is a judgment of my lord, Mr. Justice Harish Tandon,
right.
which says that they have to be classified as FMAT, RERA,
Yes.
and the central filing section has to assign appropriate.
Yes.
So my lord, that perhaps has to be corrected. In fact, we have filed the second appeal, if I may call it that, after the regulatory authority and after the appellate authority's order. That is pending. This is basically in the form of a stay application, my lord, the stay of the order which is affecting us. And I should tell your lordship, this is something perhaps which your lordship will have.
No, Mr. Bose, please clarify that we are not sure. I mean, a second appeal lies against the judgment of the.
I just hand over a copy of Justice Tandon's order. Unfortunately, my
No, this is the second appeal against what? An appellate order.
appellate authority order passed by the
Acha.
RERA. My lord, this is Justice Tandon.
So then this should be an SMAT RERA maybe.
My lord, according to Justice
Tandon held that a second.
In brackets RERA.
No, FMAT would be against the first
Yes,
court's order.
Taken care of. My lord, we'll just read the judgment. Unfortunately, I only have 2 copies and my junior is absent today.
Mr. Bose is showing my lord the Anirban Boito.
No, Merlin projects. This is because this has been referred by the stamp reporter also.
Because another matter, Justice Tandon's division bench had the occasion to deal with the same issue, how it should be classified. And we had, my lord, I was representing one of the parties there.
Doctor, in that case, I mean,
It was classified as SMAT.
Yes,
And
SMAT.
after admission of the appeal, my lord, when the my lord second appeal was finally heard, it was, in fact, we filed our written notes today. One of the issue was whether there is a provision of an appellate remedy.
Second appeal, yes.
From an order of the appellate authority under the RERA Act.
Right. Have you got a copy of the RERA Act, Mr. Bose?
I'm handicapped because of the lack of junior. I have my copy. Not got a copy there.
Which section?
58.
My lord kindly considers 58. I'll also give a copy, my lord, for lordship's benefit.
Yes, give a copy for me. 58.
ওটা মেইনটেনেবিলিটি ইস্যুতে শুনানি হলো জাস্টিস
Then, my lord, my learned friend is right. It was striking me also. Who should hear it? Whether the second appeal court, which is courtroom number 22, forget the nomenclature of the court, or
No, it has not been admitted.
But it was
We have
after
admission
admission.
hearing.
Yes.
We have admission hearing
hearing
jurisdiction. So therefore, court is correct.
No,
But
no,
what?
I have no issues about
No, we know that, Mr. Bose. None of you have issues. I mean, it is for our benefit because without jurisdiction, Mr. Dotto, why doesn't it lie? Any person aggrieved by any decision or order of the appellate tribunal may file an appeal to the High Court. And
No, whether it would be, my lord, a second appeal, which is only, my lord, on questions of law.
No.
My lord, as my lord,
It will
in
be a
CPC,
Mr. Dotto, it is like Order 21 Rule 101 appeals. If order deemed decree, first miscellaneous appeal, second miscellaneous appeal. Second miscellaneous appeal has to be heard as per the provision itself on the grounds of Section 100.
my lord, subject to being corrected, my lord, whether the order of the appellate authority would be, my lord, akin to a deemed decree or not. So that, my lord, this miscellaneous
need not be a deemed decree, whatever it may be. It's a miscellaneous appeal because miscellaneous appeal, we use the term miscellaneous when it's not a regular decree.
Not a regular.
Whenever it's not a regular decree or a deemed decree like rejection of plaint, it's captioned as a miscellaneous appeal. That is the reason for using the expression miscellaneous, not a regular as opposed to regular. Regular is against decree. Appellable order, miscellaneous. So if it was a miscellaneous appeal, whatever may be, this is a second appeal before this court, whereas per Section 58(1), grounds of Section 100 are applicable. So because it's against an order of an appellate tribunal, which is again against an order of the first tribunal. So all these are orders. Therefore, the appeals are miscellaneous, not regular.
My lord, since it refers to, my lord, grounds specified in Section 100.
SMAT has to be admitted on the substantial questions
of law.
Yes, there is no doubt on that. It has to be admitted on only substantial questions of law. Section 100 is that.
Yes.
Section 100 means second appeal. The grounds of second appeal, substantial questions of law are applicable.
Apropos what my learned friend is saying,
Yes.
I will not stand in the way if he's talking of a judgment. Kindly read Justice Tandon's single bench order.
No, but that is only on being classified as not FMAT, ordinary FMAT, but as within bracket RERA. So therefore, this will be SMAT RERA. No
This
difficulty on
question
that.
has been, my lord,
It's
argued
not a question at
on
all.
this question, my lord. We have
It's an
argued
answer to which you are putting a question.
in the statute itself.
If it's FMT RERA for the first appeal, if it's SMT
I know
RERA
the
for the
fate of the objections I raised in the other, my lord. Second
due
appeal.
to your matter, Justice Tandon has been transferred.
He admitted the appeal, of course, and framed the substantial questions of law. My lord, I was only, my lord, beseeching, though we don't have a
No,
right of-
FMT, the Justice
Cannot be
Mr.
an
Bose is saying that a second appeal was directed by Justice Tandon to be classified as FMT.
FMT RERA, if I'm not mistaken. Kindly see this judgment.
ওটা SMAP হয়েছিল কিন্তু অন্য matter-এ।
হতে পারে, আমি জানি না সেটি।
No, let us check up whether this was a first appeal. FMT RERA, কিন্তু ওই অ্যাপিলটা ফার্স্ট অ্যাপিল ছিল না সেকেন্ড অ্যাপিল ছিল সেটা দেখে নি। হাইকোর্টে তো লাই করবে না সেকেন্ড অ্যাপিল। Your appeal has been, the other appeal has been classified as SMT RERA. SMT RERA.
SMAT. That was the, my lord, caption.
Is there any such caption available in the?
No, my lord. In fact, the division bench, my lord, presided over by Justice Tandon was also facing an issue, but ultimately it was, my lord, registered as SMAT.
No, is there any RERA caption in the classification? In the computer form classifications of the appellate set rules?
We did not, my lord, find
First
it.
time this was brought into existence by this order.
But we cannot by judicial orders do that.
I had this judgment with me. I felt it my duty to show it to your lordship because this problem has to be first sorted out.
RERA বলে কোনো ক্লাসিফিকেশন নেই।
But it means inquire with the department.
কিন্তু SMT RERA তো হয়, তাহলে আমরা একটা জাজমেন্ট দিয়ে দিই আমাদের ইচ্ছে SMT RERA।
Now, better to ask the computer person, planning section,
আচ্ছা,
whether such type of classification is
Day after tomorrow.
Yes, yes. এই একটা আনিয়ে নেবেন তো ওয়েস্ট বেঙ্গল
My lord, in
RERA।
that case, my lord, both Mr. Chaudhary and myself, we would be in some difficulty day after tomorrow. If Mr. Bose does not object, can we come back on Monday, my lord?
If he does not object.
If he does not. Monday possibly will be, my lord.
Monday
31st.
31st, yes.
Monday is a holiday.
Maybe a holiday.
Oh,
Maybe a day.
that's why he's asking for Monday.
Tuesday.
We'll keep it on 1st of April, still better day.
First of April.
Still a better day, it has a different significance, 1st of April.
Some aspersion on me also. So
Very. So we'll put it on the prayer of learned counsel for the party.
Grateful, my lord.
On the prayer of learned counsel for the parties, let the matter stand adjourned till April 1, 2025. So, এইটা না অনিন্দিতা আপনি yes, yes, please.
in case your lordship needs it to look.
No, not but we need the name. ওয়েস্ট বেঙ্গল রেরা একটা একটু নোট করে নিন দুটো কপি আনিয়ে নিন কোর্টে। বলবেন এই বইটা
Real Estate Regulation and Development Act of
21টা টুকে নিন। Yours is 2021, yes. 2021 টা
The regulation is of 2021. The act is of, my lord, kindly sees it's of 2016.
Act is of 2016.
And if the Bear Act contains the regulation.
না 2016 এর একটা 2016 এর দেখে নিন উপরে
Central Act.
এই যে উপরে লেখা আছে।
ওয়েস্ট বেঙ্গল
When it is called Real Estate
This is the Central Act.
Regulation and Development Act 2016.
এই দুটো বই আনিন আর আপনি এই বই দুটো Mr. Dotto, before you leave, I'm sorry, extremely sorry. Do you have any idea how it was classified before the first?
SMAT.
No, first appellate authority, misappeal or
First appellate WBREAT. West Bengal.
Acha, very well. Very.
Well, the order will speak for itself. Can you answer me a moment?
Yes. And rest assured that whether it's registered as an FMAT or an SMAT, substantial questions of law have to be heard because Section 58 says that.
WBREAT stroke appeal number so and so.
Thank you very much.
But it arose out of an, my lord, interim order. That also has to be taken into consideration.
Interim order?
Yes. Because
I think some other
my
court
lord,
has
the appellate tribunal's
some
order.
other court must have jurisdiction.
Appellate tribunal's order, my lord, records that it is, my lord, the appeal before that tribunal is from an interim order.
What was the nature of the interim order?
My lord, I tell your lordship what happened. Very, very simply put. My lord, I'm the bank. I gave a loan, my lord, of about 600 crores, my lord, to the borrower. They are developers.
Yes.
My lord, they construct, my lord, apartment houses. And then they sell them. Now, my lord, as in by way of security, my lord, registered mortgage deeds were executed by and between the parties containing the usual clauses. The mortgage deed, my lord, consisted of a list of flats which had not been sold, which would remain mortgage. Now, behind our back, what they do is they sell some of the flats. And, my lord, they do not inform us, though the mortgage deed specifically says that money has to be routed through us, NOC has to be given by us. Now, my lord, and they do not repay the money. So, my lord, we declare it as NPA. We seek refuge or help of the Surface Act, my lord. DRT process appoints a receiver. Receiver takes possession. Suddenly, my lord, they first moved the DRT, realizing that they have no luck there. Then they move before RERA, when according to us, RERA has no jurisdiction to even pass any orders involving the bank. And then, my lord, RERA passes an order, receiver to go, physical possession to be given back immediately, and other consequential release. We prefer an appeal. The appellate authority, my lord, reinforces that order.
The Act contemplates an appeal against interlocutory orders also.
Yes.
Any order? What is the language? Any order.
There is no
discrimination between interlocutory or
There's no issue about that. So, my lord, when we lost the appellate authority before the appellate authority also, then, my lord, we preferred the second appeal, which is the statutory.
See, if that be so, even in interlocutory orders, in the case of interlocutory orders, if first appeal lies, then second appeal 58 is the only provision.
Yes.
So, therefore, in that also, you have to satisfy substantial questions.
Yes, there are substantial questions. Because what is coming in the way,
Yes.
coming in the way, is the Rajasthan High Court order, which, my lord, both the regulatory authority and the appellate authority rely upon, which says that in case of a conflict between RERA and Surface, RERA will pervade, and the bank's orders can be passed also against the bank. The crucial factor which we've been trying to prove right from the beginning is that, my lord, our deed of mortgage is prior in point of time. Our deed of mortgage is in the year 2019. It's a registered deed of mortgage, and the sale took place in 21. So under no circumstances, my lord, could this property be touched. And my lord, if that goes away, the bank is left with no other alternative. If I'm going to be throttled by RERA, I can't take advantage of Securitization Act, my lord. The bank will not be able to give a loan to any constructor. Well, there is a fallacy even in that argument, even from the point of view of Motherwit.
This will take some time.
It will take some time because we have to show your lordship. Because the Rajasthan judgment, my lord, the Rajasthan High Court judgment went up to the Supreme Court, and Supreme Court by a 4-paragraph just affirms that order. Whereas, my lord, nowhere in those two judgments will your lordship file that the deed of mortgage, a case where the deed of mortgage was executed prior to the date of sale. And I shall show your lordship to the clauses of the deed of mortgage, which clearly prohibits all such acts done by them. And here we are between the devil and the deep sea.
If it's a four-paragraph judgment of the Supreme Court, it might have omitted to consider these factors.
No, 4 maybe
6, 8, whatever. If it did not consider this aspect of the matter, prior mortgage or subsequent mortgage, then it may not be. That may be a good
Well,
case.
we shall place everything before your lordship.
Definitely.
Grateful.
Thank you. And Mr. Dottu, what about that SMAT? You have to furnish that number also. You give that number.
I'll carry that, my lord.
Today itself you have filed written notes in that.
Yes, in the other matter. Yes.
No, the other matter was registered as SMAT. So you give that number also. We'll speak with the department on that also. We'll speak. We'll prefer to. Which we'd like to have a talk with the registrar listing himself. So we'd prefer to talk with the numbers in hand.
Very good.
Please furnish that number.
Well, may I just in a piece of paper give it to your lordship?
Please do that. হ্যাঁ আচ্ছা শুনুন না অনিন্দিতা আপনি এই অ্যাপিলটা যেটা
All, one can't be heard as SMAT and one.
Yes, exactly. It's a peculiar scenario. I mean, we don't know.
But in brackets, RERA has to go in both.
I'll give your lordship the number right away, my lord. It's in the list today.
So there are logic behind both, Mr. Bose. Because if it's a remand order of a first appellate court, against that we prefer a first miscellaneous appeal, although it is in effect a second appeal. There have been adjudications, Mr. Bose, you know, must be knowing, that if in the garb of that remand, a portion of the findings of the first court, trial court, have been affirmed. It's a judgment of affirmance on that. On that, if we admit the appeal, we have to hear it on substantial question of law. Because in effect, it's not the remand portion you are challenging, but it's a substantial corroborative view of both the courts below. So there, even if it's marked as classified as an FMAT, we hear it on substantial questions of law.
A merger that automatically
The merger remains. But then, regarding the classification, it's a first miscellaneous appeal, although it's against a first appeal. So there can be instances where there's a first miscellaneous appeal against a first, or suppose in a revisional application, even if Mr. Bose, Order 7 Rule 11 application has been rejected. You prefer a revision against that. Revision is allowed. Then allowing revision is rejection of plaint. So then.
Take a cue from your lordship, what I heard your lordship say just now, heard both counsel confused, matter adjourned.
We would so love that we did not have determination to hear this matter.
Well, I have given the number.
Thank you.
Grateful by that.
এটা বুঝেছি এটা আজকেরটা এসিডিটা আজকেরটা আচ্ছা ঠিক আছে হ্যাঁ কথা বলানো হয়েছে ঘরে যে সব গন্ডগোল পাখি পালিয়েছে তো কি দরকার ছিল এসএমটি ঠিক আছে রেডা ছেড়ে ঢোকাও দরকার কি আছে আলাদা একটা
অর্ডার দিলে তো ওখানে নেবে না তো কম্পিউটার
না ঠিক বলেছেন আপনি দেখে নাকি এন্ট্রি জাস্ট From the morning we are here. You are fed up with Mr. Mukherjee.
Short password, he's coming.
He's coming. Yes. Good. Yes. What do you say, Mr. Password?
No.
Whatever you say, Mr. Dwivedi, your call now.
I would be.
He's coming means from where? He's out from his home.
Port number 3, my lord.
Port number 3?
Yes.
Where are you sitting? 16 years. Yes. Very well. Then pass over. Whenever he comes and you are ready, Mr. Dwivedi will take. এটা সাইড করে রেখে দেবেন প্রবলবাবু এলে
This is my appeal.
Yes.
This is, my lord, against an order whereby an injunction has been confirmed and finally the application finally.
There's no caveat in this.
There was a caveat, my lord. Mr. Chatterjee was.
Yes, Mr. Dottu Chatterjee.
Yes, Mr. Dottu and Mr. Chatterjee had appeared because my lord had started hearing the matter. I'm led by Mr. Chaudhary. He had started making his submissions also.
No, we were hearing the appeal itself.
My lord, the application.
Not decided.
Not decided. Undecided. It was yet to be admitted. Yet to be admitted.
Against a permanent injunction or ad interim?
Permanent. Permanent
injunction. Sorry, temporary.
Yes, a temporary injunction application has been disposed of. Injunction application has been disposed of.
What is your case? Just start your case.
Well, the suit is that a person was inducted as a lessee in respect of the property, his lease expires. He had inducted a particular tenant. Now, after his lease has expired, he has claimed that his tenant has stopped paying rent to him, and then he had given a notice of eviction to the tenant, and then sued for eviction against that particular
Subtenant was inducted prior to the expiry of the
lease.
But in the meantime, it has expired. And
in the meantime, the lease has expired.
After that, this eviction
After
notice
that, the
has been.
suit for eviction has been filed.
You are that subtenant.
I am, my lord, the person who has been inducted as a lessee by the original owner after the lease, all the leases which were subsisting had expired, including this plaintiff's lease. So I have, my lord, yes, as is where is registered lease. As is where is registered lease. My lord's recent judgment covers, my lord, this issue, my lord. As is where is registered lease, my lord, without possession, it is permissible. Unlike, my lord, where the leases were not registered. So original owner not made a party. The suit, my contention is that the suit itself it has been rendered infructuous because in 2021, much prior to this suit being filed, that tenant had handed over physical possession to the property to me. I am for the different numbers 226. I am the lessee. Now the tenant had handed over possession to me.
All the injunction application, plaintiff, opposition, all are annexed here.
My lord, sir, there are some annexures which could not be.
I'm sorry to interrupt. The annexures in the injunction application have not been.
Well, those are not legible, my lord. That's why, my lord, we have claimed leave. We are carrying copies.
Mr. Chaudhary, and I mean, there's no use hearing the admission hearing because admission hearing and injunction, if you hear the injunction, tantamount to hearing the appeal. So, furnish the whatever documents are left, you just bring those, exchange those documents, come back whenever, tomorrow or day after tomorrow. Day after tomorrow, we take up other matters. So, come back on Monday or tomorrow. We'll hear out the appeal itself. We'll make it clear in a 2 days order.
It's Millard. I'll be very Millard. I've also discovered a judgment, Millard, delivered by your lordship, Millard. So, Millard, I'll be relying on that judgment and 2 documents.
At your own risk.
Yes.
You can exchange if you want. If you can just inform yourself the judgment, yes. Citation so that you can have a complete hearing.
Yes.
Tenancy interpretation of tenancy.
Concurrent leases.
Oh, I've forgotten it. We cite that because so that I don't pass a contrary judgment this time. So I change my views every day. So for the court, you have to cite that. So
I am also quite confused about what is the correct position.
After the judgment, or
no, before the judgment, and even after that, to be very honest. Millard,
yes.
One view is Millard, old 1930 Kolkata.
Concurrent lease, can there be a concurrent lease? Did I hold that there can be a concurrent lease?
No.
Thankfully.
No, but your lordship, yes, your lordship has not held that there can be a
concurrent lease. That's settled, I thought. I mean, can there be a concurrent lease in India?
Yes.
How? In the same period without handing over possession.
Yes, but your lordship, I think, created a difference, and which is correctly so, that a lease can be created without possession. So, not the position in law, which I understood from reading.
Possession can be postponed.
Yes.
That can be done.
That's
within the definition of lease.
So that's the only window. I believe your lordship's judgment proceeded on the basis and said that you may create a lease without handing over of possession, which can only be done by a registered document. That is permissible.
I'm already sufficiently confused. Come back. We don't want to go through the rigmarole twice. Oh, Monday. Very well.
Tuesday.
In view of the in view of the issues involved in the first let us admit the appeal formally. The appeal is admitted and will be heard on all the grounds taken in the memorandum of appeal. Full next para. In view of the issues involved in the injunction application and the appeal itself being almost identical and requiring substantial hearing, the appeal along with the application be placed for hearing in the list on April 1, 2025. The matter shall, however, be placed under the heading application so that we can take it.
Yes, would 2nd April be possible?
2nd April, yes. April 1 na kore, April 2 kore. So 2nd April.
Then friends are in some difficulty.
Very well, no difficulty. 2nd April, you have no difficulty. 2nd April, under the heading application, but appeal and application will be taken up together. In the meantime, please exchange whatever documents on that date, just hand over.
Yes.
If there is no quarrel between you regarding the documents, we'll take it.
No quarrel.
If there is no quarrel, we'll create a quarrel. We are here for that.
But I'm quite excited on
Mr.
that.
Datta is there, there cannot be any quarrel after this. Unless his Mr. Dutt persona comes out.
And
If
then
that comes out,
otherwise
then
they
there can be a quarrel. If it remains Mr. Datta, then there will be no quarrel. We'll hear out the appeal itself, Mr. Dutt. Nothing more than that. But the
Problem
documents,
is-
missing documents, you'll exchange between yourselves.
Problem is if Mr. Datta's first junior comes, that is the problem.
Who is Mr. Datta?
Aniruddha Chatterjee.
He's there also in this
He's
matter.
also there. Only problem which will arise,
Ask him when he'll not be available, then we can take care of that.
he comes every day, unfortunately.
Your classmate.
If I had known a
It's
day,
your fault, entirely your fault. You have molded in that manner. Your classmate in Pune or wherever.
Yes.
In Pune, I suppose.
Thank God.
You will be the worst sufferer, sir. We can assure you that.
I'm very fond of him.
No, for that reason only.
mistakes are often made.
It's always a pleasure to listen to witty people. Always a pleasure. Yes.
Same man. Different suits, Malad?
Same. এই একই order. দুটো একসঙ্গেই অনিন্দিত দিয়ে দেবেন আপনি। 2nd এপ্রিল পরপরই থাকবে যেরকম। না না উইথ না।
Lordship, item 40, I appear for the appellant.
Yes.
This is my appeal against the refusal to my ex parte ad interim injunction, my lords.
আচ্ছা।
My lords, suit for.
So it is for the other side.
It was an ex parte ad interim injunction there, so and we didn't know
Mr.
there's
Mitra
any
should not be there.
we didn't know there's any caveat that we were informed of.
He wants a copy. Give him a copy, come back tomorrow.
I shall.
Tomorrow is all right, Mr. Mitra. No.
Or can it be day after?
No difficulty on our part, but day after tomorrow we take up appeal hearings first.
Lordship takes up hearing, so that
Hearing
day,
first.
Thursday it will not be available.
What is the nature of the injunction, short way?
Lordship, it's a suit for delivery of and cancellation of a document. The document is a gift deed in respect of a certain shares.
No, what is the injunction you sought?
Lordship, that the shares
not
are
be
not
given.
dealt with. The shares are not dealt
So, Mitra, if you have any control, please ask your client not to deal with the shares till the next date.
That is the only injunction that we have.
I mean, we won't pass any order definitely. If it's possible. We can only keep it on 1st of April. That is the only next day available. Because tomorrow, day after tomorrow, we take up hearing first. Friday, single bench. It can go even beyond 31st.
31st or 1st is the country.
Yes, that is what beyond. You are more aware than your brethren of the other religion. No religion. So we'll keep it on 2nd, Mr. Mitra.
Lordship, I'll serve a copy.
Mr. Rai, please have a talk with your client.
Only one thing, if your lordship is passing an order, the application is termed as application for stay of operation. If I could just take a leave and make it application for injunction.
The averments are there.
Averments are, it's an application for injunction, the CAN application before my lords.
And the prayer is also there for
Prayer is also for injunction, it's just titled as application for.
Leave is granted to the learned advocate and record for the appellants to carry out the necessary corrections in the cause title of the application to the effect that the same is substantial in application for injunction and not stay. First up, next para. Mr. Mitro, learned senior counsel having instruction to appear on behalf of the respondents through his learned advocate on record, seeks an accommodation and copies of the application and the memorandum of appeal. Full stop. Accordingly, the learned advocate for the appellants shall hand over copies of the memorandum and the application on the learned advocate on record appearing having instruction to appear for the respondents by tomorrow. Full stop. Try to do it today. Yes. By tomorrow. Full stop. Next para. The matter shall next be listed on April 2, 2025 under the same.
Grateful.
2nd. ওকে বলছি শেয়ারগুলো না বিক্রি করে কন্ট্রোলে Yes, Mr. Ghosh, what is the matter?
But the plaintiff is the appellant before your lordship.
No caveat?
No caveat. But the plaintiff is the appellant before your lordship.
Ad interim or interim?
But the ad interim order I got, it was extended time to time. The application for extension was also filed. On a particular day, it was vacated without hearing.
What, let us see the impugn order?
But the impugn order,
Peculiar হচ্ছে আজকাল।
order number 22 dated 20.
ইয়াসমিন ফাতিমা না তো দেখে। না, শুধু না এও ধরেছে ওই একই, এও ওই একই জিনিস শুরু করেছে। He did not move the petition. What could the court do?
Lord, I cannot justify these things, but the application was filed on that particular day. Lord, I have not stated many things, Lord, because it is my institution. The learned just said the all other matter are released. But I did not disclose everything in my petition because this is my institution.
So other matters are released means before your matter was taken up?
Yes, Lord, the learned.
Oh, after that it was taken up?
Yes. Learned judge was busy with the other matter, ad interim matter, and other matter was released. That was the info.
What was the injunction you originally got?
Lord, the page page 76. Lord, the status quo as regards the nature character of the court.
Extension reject court.
Page 60?
Page 76, Lord, of the stay petition.
ও বলছে আধা ম্যাটার রিলিজ করেছিল তাহলে নিয়েছে সেটা। তিনি আবার ইয়াসমিন ফাতিমা ছিলেন, তিনি দিয়েছেন এখানে। The limited question which arises in the appeal is whether the learned trial judge was justified in refusing to extend an ad interim order of injunction which was initially granted and subsequently extended from time to time by the impugned order, only on the ground that the application was not moved, without looking into the merits of the application. Full stop. We find from the records that the initial ad interim order of injunction was passed on May 31, 2023 to the effect that both parties were directed to maintain status quo over the suit property and restraining the defendant and or his men and agents from interfering with the plaintiff's possession of the suit property and from preventing the plaintiff from using the common space, staircase, roof, water connection, etc. Full stop. Next para. The appeal is hereby admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. Since the prima facie case for injunction has been made out, we hereby direct the parties to maintain status quo with regard to the suit property and restrain the defendant stroke respondent and or his or her. How many defendants?
Lord, the only one.
Yes, Lord. One. Him. Defendant stroke respondent and or his men and agents from interfering with the plaintiff stroke appellant's possession in respect of the suit property and or from preventing the access of the plaintiff appellant to the common space, staircase, roof, water connection, and other common amenities in the suit property till disposal of the present application. First of the appellant shall serve a copy of the application on the respondent indicating that the application shall be listed for hearing on April 9, 2025 when an affidavit of service to that effect shall be filed by the appellant.
Great.
Next.
The respondent.
Yes.
To recollect, Mr. Chaudhary was addressing your lordship on that stamping issue.
Mr. Jishnu Chaudhary?
No, Mr.
Shobhujay Chaudhary, yes.
Ananda Mitra had argued.
Yes, right.
Sir, may I start, Mr. Chaudhary? Will?
Yes.
Now, a question that fell from your lordship after we commenced the arguments was that one of the grounds in the impugned award was that because the petitioner or the respondent in the arbitration had claimed that the agreement is null and void, whether invoking section 64 and 65 of the Indian Contract Act, whether the arbitrator could have passed an award directing their eviction. Because as you lordship would recollect, when we are assailing an interim, they have assailed an interim award of eviction before your lordship. Now, may I kindly show the pleadings that are there? Because it also, I will be wrong if I don't point out, it also fell from your lordship because the division bench judgment which Mr. Chaudhary showed your lordships at length, that ultimately held that the agreement was not null and void.
Mr. Bushmuli, this will take some time.
This will take some time.
Mr. Mukherjee and Mr. Chaturvedi, your matter is released because we'll release all the other matters because this will take some time. So other matters are released. Passover, হ্যাঁ পাসওভারটা রিলিজ করে দিন ওনাদেরটাই পাসওভার ছিল তো উনি তো প্রবল মুখার্জি yes other matters are released all other matters are yes.
Very briefly, my lord, that division finding of the division bench, if I may just trouble your lordship very briefly, page 174, volume 1.
One second, please. Yes. Good.
Lordship kindly comes to the second paragraph. We do not agree with most of the reasons recorded by the learned court below for setting aside of the award. However, it does not permit the conscience of this court to sustain an award which in effect and substance allows the appellant who had no right whatsoever to the said premises to remain in occupation of the said premises without payment of any occupation charges. If, as rightly held by the learned arbitrator, Efcalon had no right to license out the said premises, the appellant who had been inducted in the said premises, kindly notes this, had no right to be in occupation of the said premises. It is a fundamental principle of law as enunciated in section 64 and 65 of the Indian Contract Act that a party rescinding a voidable contract is obliged to restore the benefits derived from the agreement, from the contract. Even if a contract were void ab initio, all benefits received thereunder would have to be restored. The appellant was obliged to pay occupational charges for the period during which the appellant was in occupation, if not to Efcalon, at least to Kolkata Port Trust, the owner of the said premises. In our view, the learned arbitrator committed a fundamental error in law, not directing the appellant to restore the status quo ante at the time the appellant was put into possession of the said premises. The award, in our view, is patently illegal insofar as the award allows the appellant to remain in the said premises, enjoy the premises and or carry on business thereat without being saddled with any obligation. The impugned award is unconscionable and thus against public interest. This is, I will just highlight one issue over here. What fell from your lordship that because the division bench otherwise did not held the agreement to be null and void, but what ultimately the division bench held against the appellants or the petitioners here is that they contend that the agreement was void. It is their contention throughout. In the first round of arbitration that was invoked by them, in the section 30.
So Mitra took up a point that even if they contend, but it's not actually held to be void, then whether this principle can be applied. But you probably, Mr. Chaudhary also highlighted these two aspects of page 174, second paragraph. It was not qualified with non-payment of occupation charges. It was unqualified, who had no right whatsoever to the premises to remain in occupation without payment was an adjunct.
Yes.
And also the next portion of that, the last few phrases of that second paragraph, if Efcalon had no right to license out the said premises, the appellant who had been inducted into the premises had no right to be in occupation.
Also,
so this was the premise of
as
Mr. Chaudhary pointed.
The concluding portion of page 174.
That too, yes.
That also.
Was obliged to be aware for the period, yes. Very.
It's a lordship's leave, Mr. Chaudhary. Great.
Well, on the last occasion, Lordship had asked me a question that whether the stand taken by them that the agreement is void, which was found by the first arbitrator, if the award is set aside, whether the principles of section 64 and 65 of the Contract Act can apply after setting aside of the award. That was the query by the by the court. Now, my lord, to that, my lord, my submission was, and I had just started that when we had last parted, the award in question has been passed under section 31(6), which is in the nature of judgment upon admission, without requirement for trial. The 31(6) is interim award.
Is it on always a judgment on admission?
No, in the nature of. I'm not saying that.
Even is it in the nature of a judgment on admission?
No, but a judgment on admission word is not written there. Interim award can be passed in respect of any subject matter which is the subject matter of
Parameters
the
have
main
not
award.
been given. Parameters have not been given.
Not been. It is more wide. It is wider.
Judgment on admission in the sense that it precedes the main.
Correct.
Very
So, but the essence is that without requirement of a trial as such in the arbitration proceedings, whether the award can be passed or not. Now, before the arbitrator at the second instance, after my lord, we went back in arbitration, there was a role reversal in the sense that my clients became the claimant. My clients were the respondent over there who had a counterclaim. They became the claimant. We asked for the eviction on, my lord, all the 3 points. The cause of action pleaded was the license has expired. The period has expired. It has been terminated before that.
Yes.
If you consider it is a lease, then also under 106, there is another letter by abundant caution. And more importantly, since you yourself, you are saying it is, the agreement itself is void, and you are admitting that I have been put in possession by virtue of the agreement under 64 and 65 of the Contract Act, you are first to give it back. These were the 3 or 4 points on which, my lord, the claim is based, and on that basis, the application for interim award under 31(6) of the Act was based. Now, apropos that, the award which has been passed by the learned arbitrator, my lord, there are 3 sets of findings. And one of the finding in that is the principle of 64 and 65, where the division bench has been quoted, and my lord, what lordship has just now seen, my lord, which my junior was placing and lordship was asking, that is one of the fundamentals.
Yes.
So, my lord, this is because one query was that whether the arbitrator had to independently come into a finding or whether this presupposes that the agreement is void.
Yes.
That is, my lord, that on the last occasion, this was
claiming that it is a void, whether that can.
Whether because the arbitrator is not coming to a finding that it is void.
Yes.
But then he is saying 64, 65.
Right.
Well, the principle over here is interim award, that your best defense, because, my lord, now, my lord, Supreme Court has settled it that in cases of, my lord, summary judgments, which is also includes, my lord, Order 12, Rule 6, judgment upon admission, the test is that whether there is even a remote possibility of the defendant to succeed.
That is in respect of an Order 37 or a commercial suit scenario.
No, my lord, even interpreting Order 12, Rule 6 also.
Order 12, Rule 6 is much easier, in fact, in a sense that there is an admission, there has to be an admission.
No, my lord,
but if it's not an Order 12, Rule 6 scenario.
Now, my lord, the test has been, if I may say so, earlier, the test was that there has to be an admission in black and white, either in the pleading or otherwise, as the language of Order 12, Rule 6 says, either in the pleading or otherwise, by the person concerned against whom we are seeking the decree. That was, my lord, the test.
Yes.
Lord, that has been, I won't say watered down, that has been widened now. And, my lord, the test post 2000, lordship will find, my lord, if we analyze the judgments, my lord, in Order 12, Rule 6, the test is that, my lord, whether the defendant has even a remote chance of success. I am not talking of defense is moonshine, leave to defend. What is troubling your lordship? That is order 37 in original side chapter 13A principles. Somehow I create a triable issue. If we are holding brief for the defendant, we come and say, all right, this is a disputed question of fact. You have to wait till the witness goes up in the box and does it. But my lord, even under Order 12, Rule 6 principle, the Supreme Court has now laid down the test that the test is that we will consider it at the trial or as a trial stage only if the defendant indicates it has a remote chance also of success. Now the question over here is Order 31, Section 31, Rule 6 application. My lord, the arbitrator in the Section 16 has expressly held, because in the Section 16, my lord, before the 31(6), there was a Section 16 application filed. Over there, the contention was, it is a lease, it is unregistered, therefore there is no arbitration agreement. The Section 16 order is there. Yes. Section 16 was dismissed by the arbitrator, holding that no, it is a license, registration not required, and you yourself have treated it to be a license in the first round. But you say that the agreement is void. That's a different thing. But this is a license, and that's the Section 16. Now, my lord, very well, Section 16 can also be a ground under 34. I am not joining issue. So essentially, I have to satisfy your lordships on 3 counts. If it is a license, we don't have any problem at all. We take it simpliciter as a license. License by its very nature is revocable. It is not being by its very nature revocable. There is a revocation letter.
Institution of the proceeding is sufficient.
And they have themselves done it. Institution of the proceedings itself is. Absolutely. That is also a notice. Now, my lord, the second comes that whether it's a lease. Whether it's a lease. Now, if it is treated to be a lease, then also there is a 106 notice. No question of, my lord, it's not a registered document. That is why, because it is not a registered document, it can be terminated by 106 notice. And so far as license or lease, whichever way lordships looks at it, or rather if it is a license, expiry, it has expired by efflux of time also, because my lord, it was only for 6 years. Now, my lord, on the merits, their case is of misrepresentation. Why they say it's void? It is a case of misrepresentation by us, that's the allegation, that we did not have a right over the premises from Port Trust, because ultimately at that point of time, we did not get a formal lease. Now, my lord, in my opening argument, I showed to your lordship from the license agreement itself and the recital that the very reason why it was held to be a license by the arbitrator, and I shall show the Section 16 order also, the recital records that I have been unable to get a lease, a formal lease executed.
As and when I am granted.
Therefore, a license is being granted.
Yes.
If they want to continue, and ultimately in the meantime I get a license, I get a lease in my favor, then parties will.
Mr. Mitra said that it will be in the same terms, but you say that it will be in the same terms. That was never granted.
That was,
remained a license.
If they say it will be in the same terms, that is this is a license. You at best can
that
say,
was never granted.
I am entitled to a lease, but that is not the case they made out before any of the arbitrators.
That it was granted actually.
Because, my lord, the lease by the Port Trust in favor of my client, my lord, took some time. There were legal issues. It took some time. It ultimately came, my lord, with retrospective effect from that date, but after around 10 years or 15 years, it came after.
Mr. Chaudhary, probably the most interesting argument advanced by Mr. Mitra was that if it's a juror relationship, because as per the judgments held, if it's not a registered lease, it's a monthly lease, then it's not. It flows from the Transfer Property Act as interpreted by the courts. Then it's a right created by legal fiction or by the law. So it's not a right flowing from the contract. So therefore, if it's not a right flowing from the contract, it's not covered by the arbitral clause. It's a different statutory jural relationship.
That this argument has been, if I may use the expression, inspired by, my lord, one of my lord's judgment, my lord, sitting singly
What did
in
it,
the
again,
commercial court suit, my lord, interpreting a section, my lord, sorry, in 227 jurisdiction, where my lord Justice Bhattacharya has been pleased to hold that if it is under section 106, it is a contractual determination which is flowing, sorry, it is a statutory determination and it is not flowing from a contract. So it is, since it is not flowing from a contract, it cannot be a commercial commercial dispute, because
that's a different context. I mean,
no,
if it's not a
it is,
commercial
my lord, my answer to that is, my lord, of course, that context, my lord, we now have another view. Now it has been referred to a larger bench also. It will be one of the interesting factors, my lord, because, my lord, now it's really a, whichever way you file a suit, my lord, the defendant either is taking advantage of my lord's judgment or is not. But that is, my lord, the beauty of this profession, my lord, we, till it is there. But, my lord, my take, apropos what fell from your lordship, is that a lease per se, whether whichever way, whether it is registered, unregistered, a lease is a contract. There cannot be a lease without a contract, whether statutorily or act of parties.
Yes.
What statute under transfer of property does is, if it is a lease for less than 1 year, it recognizes the written contract between the parties.
But the arbitration clause is in that agreement.
Now, my lord, that dispute is no longer there because arbitration clause is independent existence. Section 16 clear. We have numerous Supreme Courts there.
No,
And
undoubtedly.
this has also been taken note by the arbitrator while dismissing their Section 16.
No, not on that exactly.
And, my lord, the second admission, which is relevant over here, I have shown your lordship the pleading in the earlier proceeding before the erstwhile arbitrator and also here. It's an admitted possession. The possession, they are put in possession by virtue of that agreement.
Yes.
That, my lord, has been there in the pleading. It has been noted by the arbitrator also. This is a very big, and it is there in the, even in the counter statement which has been filed before the, and if I may use the expression, present arbitrator or the second arbitrator.
Yes.
So I admit I come in possession by virtue of an agreement. Then I turn around and say that I come in possession by virtue of the agreement, but the agreement is void. Therefore, before the first arbitrator, my case is, whatever I have paid in the 4 or 5 years when I did make payment, give me back. Now, that award having been set aside, the position before the second arbitrator or in the second tranche of proceeding remains the same, in the sense that they still continue to take the defense that the agreement is void.
And have they reiterated in the second time before?
Yes, yes. My lord, will kindly take the pleading. Kindly takes page 290, volume 2. One line বললি আমি আবার আরেকটা জায়গায় মার্ক করেছি হ্যাঁ ঠিক আছে ঠিক আছে ঠিক আছে বার করে নিচ্ছি
Yes, yes. Void and voidable. It was underlined by some predecessor of ours.
Well, this matter has a checkered history. Before the earlier bench, my lord, this is really a rehearing which Mr. Mitro had completed his argument before the earlier bench. We had just started, and then, my lord.
What happened to that bench? Broken?
No, my lord, it was Justice I.P. Mukherjee got elevated as the Chief Justice, and
This also went to Justice Tenant?
No.
Then you would have a good precedent.
No, thereafter, my lord, I believe it went to that was released and then my lord released Justice Tandon, it had gone, but Justice Tandon had released it. So you can still draw an inspiration, my lord, as presidential event.
Right.
Well, at page 290, para 18,
Yes, it's actually, I mean, void and voidable. You can see
in
that.
view thereof, also for reasons herein
Actually, both
above,
the judges underlined.
invalid, inoperative, unenforceable altogether, respondent further state. Now, kindly see what is their case. Well, lease and all this argument on the first blush, it looks very attractive, but their case is they are not saying I am a lease, I am a lessee of yours. They are saying I am a tenant of port trust. The respondent further states that the respondent as a lessee or monthly tenant under KPT in respect of said premises is continuing in exclusive and lawful possession. So how can, my lord, Mr. Mitra argue, or they can argue that I have a right to evict them, but perhaps in the suit and all that, because this is not there. On one breath, they admit I come into possession by virtue of this agreement. I have shown your lordship that. And on the other breath, they say now the case is I am a direct tenant under KPT. Well, kindly see page 561, which is, my lord, their opposition to the 31(6) application. That is the application of interim award we file, their opposition. It starts at page 561. At page 567. Volume 567 at page 5. Volume 3. Volume 3. I am sorry, I gave a wrong page. It is 567. My learned junior directly.
Yes.
At 567, and this is before, my lord, this is the second round of litigation. Lordship will find at 567. This is the second arbitrator.
What is this? Their opposition to the
Their opposition, yes. Para 2 will it will be evident. I have read a copy of the petition by the claimant under 31(6) of the Arbitration Act.
Right.
Well, kindly come to page 571. Now, my lord, I want to show your lordship first, my lord, para D. They admit I am in possession and they get possession from me. However, in the meantime, the said purported agreement dated December 26, 2004 was entered between the claimant and the respondent when the claimant was in possession and occupation of the suit premises only as an interloper. So they are calling me an interloper. And had no manner of right, title or interest in the said suit premises to enable it to grant any license or lease in respect of any portion thereof in favor of the respondent or any third party, or to deliver lawful possession thereof. Nonetheless, the respondent went into possession of the suit premises subsequent to the execution of the purported agreement dated 26 December 2004 and paid agreed rent to the claimant in terms of the said purported agreement of 26 December 2004 till end of September 2010.
Aren't they barred under section 116 of the Evidence Act?
Yes.
Even if it's a license. License or lesser.
You cannot
Can challenge the title of your inductor. No. Either landlord, lessor or licensor.
You can't do that. Now, my lord, here there are threefold admission. Number one, I am in possession. Number two, you take possession from me. And number three, I get possession because of this so-called agreement.
Yes.
And number four, they pay money to me till September 2010 under that written document. And now, my lord, kindly come to page 577, paragraph 16. Last four lines before fifth line from the bottom, para 16. I repeat and maintain, the claimant never had and still does not have any alleged right, title or interest in the suit premises and hence had no right to grant any lease or license in respect of the suit premises either in favor of the respondent or anybody else. In view thereof, and also for other valid reasons as stated herein above, the said purported agreement is void, voidable, invalid, inoperative, unenforceable altogether. I further state, respondent as a lessee or monthly tenant under KPT of the suit premises is continuing exclusive and lawful possession thereof, and any allegation to contrary. So, my lord, if his main defense is that I am a tenant under KOPT, how can he raise a question of any registration of lease, stamping of lease, and all that? And even so, according to him, there is neither a valid lease nor a valid license. But he is admitting that piece of document. And if I am to get a decree, if I assume for the sake, my lord, in a demurrer application, or my lord, even the principles of, my lord, in fact, section 64, 65 is proceeding on the principle that if you say it's void, before you are alleged to argue, or you can be heard to argue that it is void, you are first to surrender possession. But I just, judgment about Calcutta, Calcutta. This is an interesting judgment, my lord, because, my lord, we often Xerox gulo anoni enecho asche.
You can file the Xerox photocopies with your written notes.
Lord, I just want
there for us also.
Because, my lord, Lordship can just make a note. I'll file it.
You just read out from there.
My lord, this is the judgment of, my lord. It's an old judgment of Justice Sanderson, Chief Justice Sanderson, and Justice Justice Ashutosh Mukherjee. Now, my lord, this is relating to, my lord, Evidence Act 116, what fell from your lordship. Now, in my judgment, the plaintiff was entitled to obtain a decree for possession of the land because the learned subordinate judge had found in favor of the plaintiff in respect of the tenancy of 1910, and in view of that finding, in my judgment, the defendant was not entitled to set up his title against that of the plaintiff without, in the first instance, going out of possession. If you are to set up a title which is contrary to the landlord, the first thing you have to do is go out of possession. Well, I read this line again. In my judgment, the defendant was not entitled to set up his title against that of the plaintiff without, in the first instance, going out of possession and restoring possession which the plaintiff had delivered to him by means of the tenancy of 1910. This principle was laid down so long ago as 1832 by Chief Justice Tyndall in the case of Dodem Manton versus Austin in these words. The principle is that a tenant shall not contest his landlord's title. On the contrary, it is the duty to defend it. If he objects to such title, let him go out of possession. So, my lord, and my lord, this the reason why I shall cite it formally. I shall give the hard copy. The reason why I cite this is that, my lord, if they have taken this, even for them to argue either before a court or a tribunal, they will first have to go out of the possession. And this principle, read with, my lord, what lordship has already seen, the earlier division bench judgment presided by Justice Indira Banerjee, my lord, 64-65. My lord, 64-65 is an offshoot of 116 or has a close nexus to that if lordship sees in that way. Because, my lord, what is happening is that, my lord, when a tenant or a licensee or a person in possession is trying to challenge the title of the person who has put him in possession, he is trying to, which is the principle of 116.
Rather, 116 is a species of 64-65. 64 is wider.
Wider.
Contracts, all contracts. Whatever you deny, if you say it's void or voidable, you return the benefits you have
Correct, correct.
You can. That's against also in consonance with appropriate reprobate principle.
Correct.
Same thing.
Appropriate reprobate principle also, my lord, we had cite Karam Kapai, the learned arbitrator has cited that.
These are different facets of the same crystal.
It's the same crystal. My lord, the entire logic is that you can't be Kalidas. You can't, my lord, you can't sort of chop the branch.
No, you can fall down. You can be Kalidas and you have to fall down as per Justice Mukherjee. You fall down, go out and then we.
Well, that is, my lord, this is a safety measure in the sense that you come down and then you try to chop the branch. If you
Yes.
sit on if you sit on the branch and start chopping it, it is your downfall. So, my lord, it is based on this principle. So, my lord, if we keep these principles in mind and now have a look at the award. Yes, my lord, what fell from my lords just now, my lord, page 928 in the section 9, which I told your lordship on the last occasion, the section 37 out of the section 9 was decided later.
Yes.
But lordship had said these are in light of section 9.
If you cite another volume, then we will be out of sight.
But I'll keep it very.
No, Mr. Chaudhary, this was just in jest. 928.
928.
8.
This is volume 4. Volume 4.
Yes.
This is internal page 28 of the division.
Why did
bench
just stand and release on the ground of the volumes?
He personally knew the.
They found out some ground which you are not available to us. কাউকে চেনেন না
Oh.
কাউকে চেনেন না এদের মধ্যে কটা জন আচ্ছা yes
Well,
so here 116 is mentioned.
Yes.
Right.
Well, first
this is a
I told
part
your
of.
lordship that is the execution of the deed of
What is this? What is this, Mr. Chaudhary?
This is the section 37 order arising from section 9.
All right.
Which was passed on the same day, but my lord, the hearing was concluded at a later stage.
Yes,
First,
yes.
the hearing of the section 37 appeal from the section 34 was concluded.
Right.
Then, my lord, the hearing of the section 37 from the section 9 was concluded. So, though both the orders come in on the same day, are pronounced on the same day, the judgments, well, there is a distinct difference in approach of the division bench, because in section 9, by the time it was argued, well, we had been able to place before the Honorable Division Bench the subsequent lease of 2015.
Yes.
And that has been noted in the second paragraph of this page. In view of the execution and registration of the deed of lease dated 23rd June between Kolkata Port Trust and Efkalon, whereby the said premises has been leased out to Efkalon for a period of 30 years with retrospective effect from 4th August 2013, this court has no option but to proceed on the basis that Efkalon was at all material times in lawful possession of the said premises. In any case, Star Trek having been inducted by Efkalon in terms of a license agreement, Efkalon is estopped under 116 of the Indian Evidence Act from questioning the right of Efkalon to possession of the said premises. And all this is taken note of the note by the learned arbitrator. My lord, kindly now comes to the award at 785. Volume 4, same volume, 785. Let kindly first comes to my lord, page 799, para 24.
Yes.
The learned arbitrator takes note of the appeals which were filed under section 9. First, my lord, up in para 22, my lord, 22 and 23, the arbitral tribunal takes note of, my lord, the orders of the appellate court arising out of section 34. I am drawing my lord's attention to para 24. It appears that two more appeals, being FMA so-and-so and so-and-so, appeals preferred by the claimant and the respondent respectively from an order under section 9 of the Arbitration and Conciliation Act, also arising out of the agreement dated 26 December, were disposed of by the judgment of the Honorable Division Bench passed on 20th May. The said appeals, while being dealt with by the Honorable Division Bench, inter alia held as follows. Then, my lord, kindly come to page 800. internal page 16, my lord, where the quotation is, my lord, the third paragraph of the quotation, which my
Yes.
lord, this is the same quotation. In any case, the award having been set aside and an appeal filed in this court from the judgment and order setting aside the award having been dismissed, Star Trek cannot claim the benefit of the award. Then, my lord, prima facie so and so. My lord, this has been quoted because even before the arbitrator, it was said or argued that the award of the erstwhile arbitrator, it is only part setting aside and not full setting.
Yes, yes.
So, my lord, this was quoted.
On that occupation charge.
Correct, correct. Now, my lord, kindly comes to para 30 at page 804. 801 है किसी जगह है? I will kindly see the reason why I show your lordship para 30. What was the argument before the learned arbitrator? Because lot has been now argued. This is what was argued before the arbitrator. The respondent through its counsel has submitted that the main claimant of the claimant is itself not maintainable and therefore petition under 31(6) is not maintainable. Referring to section 31(6), Mr. Mukherjee has submitted that although the arbitral tribunal has the power at any time during the arbitration proceeding to make an interim arbitral award, but such power can only be exercised on any matter with respect to which it may make a final award. According to Mr. Mukherjee, this tribunal cannot and does not have the jurisdiction to decide the claim made in the claim petition, and therefore following the provision of 31(6), it cannot make an interim award. Let it be recorded and repeated that instant arbitration proceeding was challenged by the respondent at the outset by filing application under section 16. That petition, as already taken note earlier, was taken up as a preliminary issue, and it would be necessary to mention in the petition also the respondent had prayed for a preliminary order holding that this arbitration proceeding did not have the necessary jurisdiction to adjudicate the dispute in question and or to adjudicate the dispute raised in the statement of claim. The petition was looked into, dealt with and dismissed by a final order on 14th April 2017. Consequently, this argument of Mr. Mukherjee cannot be accepted. Next submission is that the earlier award has not been set aside or cancelled in totality. Most of the earlier award is still valid, notwithstanding the same being set aside by the High Court. Mr. Mukherjee drew my attention to paras 5 to 10 of the petition under 31(6) in support of his contention that whatever had been claimed by them as a counterclaim to the earlier arbitration now forms part of the main claim in the arbitration proceeding. So, my lord, this is also argued. That is why, my lord, the arbitrator relies again on 64, 65.
So this was on void and void.
Yes.
This counter.
Yes.
Yes.
Mr. Mukherjee drew my attention, learned counsel refers to the prayers enumerated in paragraph 39 of the petition under 31(6) and submits that the same is equivalent and or similar to the counterclaim filed by the claimant between 5 to 10 taken note of in the above paragraph. Drew my attention to page so and so for the purpose of highlighting his submission that accrual of cause of action was indicated in the earlier proceeding and the facts were very succinctly dealt with. Mr. Mukherjee then drew my attention to the observation of the erstwhile arbitrator at page 122 and stated that the observations made therein have not been set aside in appeal by the High Court. Lord, what they really tried to do before the second arbitral tribunal, they said that, look, the observation that the earlier agreement is void, that has not been set aside. What has been set aside is that after holding that you had no right, you should have directed that you cannot, they were not asked to leave. But the fact that the agreement is void, that has not been set aside. That is why, my lord, they try to latch upon to the earlier award, my lord, which was there. My lord, that is, and my lord, to counter that, we showed, my lord, the order of the division bench. The division bench, my lord, by upholding has clarified. Because even before the division bench, same argument was advanced. That no, it is only partial setting aside of the award. So, my lord, that is why 64 and 65 principles we had to go to. Because they repeated, they try to latch on to the finding of the earlier arbitral tribunal, and now before your lordships a different case is being made out, that no, It is a lease, it is therefore either registration or a stamp act. No, I shall answer it. I'll come back.
We'll continue tomorrow.
Yes.
Harding part for further hearing tomorrow. এগুলো একটু হেল্প করে দেবেন না